A murder has shattered a family in Soweto, leaving them searching for answers. They are struggling to cope with the brutal way their 62-year-old grandmother was killed. This tragedy unfolded after her own granddaughter, 33-year-old Nomaswazi Tshabalala, admitted to the crime in court. She recounted how, during a fierce argument in 2019, she killed and buried her grandmother in their backyard. Now, she faces her family as a cold-blooded killer, confronting the pain she caused.
Struggling a lot with this. It's hard to accept, it's hard to process, but I hope at the end of the day we'll be able to find closure and move on with our lives.
In court, the 33-year-old finally spoke up.
On the charge of murder, how do you plead?
It was not my intention, my lord.
So you plead not guilty?
No.
Guilty, my lord.
In a plea deal, Nomaswazi Tshabalala disclosed how she killed her grandmother during a heated argument that seemed to be fueled by drugs.
After smoking, I went back to the house and I found the deceased already picking out my things and placing them in the kitchen. She continued yelling at me and we ended up engaging in a fight. I took a calabash and hit her once on her head and she collapsed. Paragraph 4, I became so frustrated in that I didn't know what to do. I went to my bedroom and I smoked again. After smoking, I went back to her bedroom, in brackets, the deceased, and I find her snoring. I then suffocated her with both my hands until she was emotionless.
Nomaswazi Tshabalala also admitted to stealing her grandmother's bank and social security cards, withdrawing over 15,000 grand from her accounts.
I think we will find closure as a family knowing that the person is sentenced accordingly to the crimes she committed. I'm not someone who is heartless, but when it comes to a situation in jail, I don't think I'll be able to forgive her.
Tshabalala sat with her face down, appearing to cry as the horrific details of how she killed her grandmother were read in court. The 33-year-old has been found guilty of premeditated murder, and the state plans to seek the harshest penalty of life in prison. A criminal who caused significant trouble around Albuquerque tried to charm the judge, but ended up receiving a harsh sentence. He didn't leave quietly and had to be escorted out of the courtroom, but not before he seemed to threaten a woman. Anthony Lujan spent a few minutes telling the judge how he had learned from his mistakes, but that was before she handed down his prison sentence.
What?
This was not how Anthony Lujan had envisioned his sentencing would end. Just moments earlier, Lujan had been telling the judge that he was a changed man.
Way more life and violence and coming to jail. I've worked hard to change this way while I've been in jail.
There was a lot to address. Lujan pled guilty to 4 different crimes, including a well-known incident in Albuquerque where he was caught on police video last year, crashing a truck while trying to flee from the police. He then ran into a Cracker Barrel to hide before being apprehended. He was also being sentenced for a road rage case in which he shot at a teenager, a burglary, and for assaulting his then-girlfriend's son. That ex-girlfriend asked the judge to impose the maximum sentence.
Don't let another child get hurt. Don't let another mother suffer my suffering. And please don't give him any satisfaction of any kind of freedom at this point.
The judge agreed and handed down the 12-year maximum sentence as part of his plea deal. As security escorted him out of the courtroom, prosecutors reported that Lujan turned to his ex and mouthed, "Watch it." Then he had a meltdown.
What?
Judge Flores could have sentenced Lujan to as little as 2 years in prison. In the road rage case, police reported that Lujan pulled out of a parking lot on Old Coors and nearly collided with a 17-year-old driving with his father. Lujan then followed them and fired a shot at their car. The 23-year-old accused of killing her mother in Miami Township appeared in court. This isn't Anna Millet's first time in court. She served over 8 months in jail for felonious assault after attempting to run someone over with her car. There had been court proceedings leading up to that incident. Fast forward to the court appearance, where Millet now faces charges after police say she killed her mother, nearly ran over 2 officers, and led police on a chase that ended in a crash. Millet appeared emotional in the courtroom, but only expressed her emotions verbally when her bond was being set.
From the crashed motor vehicle and from the hospital as well.
I can't walk.
Given all of that, Your Honor, I would submit that a $5 million bond would be appropriate in this case.
In court, Millet was visibly emotional as prosecutors discussed the possibility of her fleeing if she were released on bond. At one point, she appeared to scream, "I can't walk," as they spoke. Despite her outburst, the bond was set at $5 million for Millet, who is accused of using her car to run down and kill her own mother. Prosecutors then went on to describe what allegedly took place during the tragic incident.
Video evidence exists of the defendant charging her vehicle through the yard, backing up and charging again at least 3 times. On that final charge, the defendant chased JM with her car into the garage where she crashed into the back and side walls and pinned JM.
During the hearing, the prosecutors referred to the victim, Joyce Millet, by her initials. JM Anna Millet, accused of killing her mother, is scheduled to return to court. Family members filled the courtroom, holding a large picture frame with photos of their loved ones, as they prepared to speak to the Canton man who took their lives.
We have nothing but memories. We have nothing but screensavers and posters we have to kiss.
Lee was pushing his daughter in a stroller on Cross Street in Akron when they were both struck by Shawn Allen's vehicle.
He's a coward.
Investigators say the 37-year-old targeted Lee after an argument at a nearby bar and then intentionally ran him and his daughter over with his SUV.
He chose to hunt them down like dogs.
Allen was sentenced to 2 consecutive life terms plus an additional 3 years. He will be eligible for parole after serving 63 years.
Why is he eligible? Life is life. By law, he needs to die. You got 6 kids, and you okay to sleep at night knowing you ran down a baby and ripped her from a stroller?
Lee's family stated that Allen had shown no remorse since he ran over their loved ones. A Raleigh family continues to mourn the loss of 31-year-old Raheem Cummings, who was shot outside a shopping center and died the following day. Witnesses reported that a foot chase preceded the fatal shooting. When the first suspect appeared in court, emotions overwhelmed Cummings' widow and the large group of family members who attended the hearing. As family members escorted the distraught Kanai Cummings into the courtroom, 18-year-old Javery Thompson quietly raised his hands and said, "I didn't do it." Thompson and another teen are accused of killing 31-year-old Raheem Cummings. This is not Thompson's first encounter with the law. Criminal records show he was convicted of felony gun possession in 2015. Also accused is Zyreek Avery Braxton. Both Thompson and Braxton were ordered to be held without bail on the murder charges. After the court appearances, Kanai Cummings shared her thoughts on the outcomes in court.
He needs to know. He needs to hear my voice. He needs to know. He needs to see my face. He needs to know that this is real. You tore a family apart. This is real. And I want everybody that was involved. I want every single person to face what they need to face. They need to be punished, everybody involved.
During those court appearances, the prosecutors did not provide any motive for the crime. A judge delivered strong words during the sentencing of a man who killed his estranged wife in front of their daughter.
Mr. Lynch, you're going to go to prison for basically as long as I can send you.
Joshua Lynch will spend the rest of his life in prison. The judge announced this sentence a week after finding him guilty of several serious charges, including murder. Cuyahoga. Judge David wasn't the only one who believed convicted killer Joshua Lynch deserved a tough sentence for killing Jovan Ferguson Lynch. Her family members were also present in court, explaining to the judge why he should face life behind bars.
This has affected us beyond I can't even put it in words. He took a mother from a daughter from a mother, a sister from a sister, and an aunt from her nieces and nephews. He took her from us. He took my baby sister from us. And my niece don't have a mom. Nor does she have a.
Then her mother spoke, the one raising Jovan's daughter, the girl who witnessed her father kill her mother.
My daughter ain't gonna never see her mother again. I can't never I got custody of her. I can't take the place of her.
I can't do it.
They requested the maximum sentence for 36-year-old Joshua Lynch, and the judge agreed.
Mr. Lynch, if there was ever an individual who doesn't deserve to walk free amongst organized society, it's you.
The judge convicted Lynch of 2 counts of murder and several other charges, including gross abuse of a corpse, after a bench trial. He sentenced him to 28.5 years to life. The judge highlighted that Lynch shot Jovan twice in February 2023, while their daughter was in their Cleveland home.
Is this fun for you?
Lynch smirked as he heard his sentence.
I don't understand why you're smiling.
He was on the streets and able to kill Jovan despite having a dozen prior felony convictions. After the hearing concluded, Jovan's family celebrated. Her family shared that the sentence means little to them. It doesn't bring Jovan back. Joshua Lynch chose not to make a statement during his hearing or explain why he laughed and smiled while being sentenced to life in prison. The final chapter in the murder of beloved auto parts store manager James Haller Jr. concluded with an emotional outburst in court. The 2 women responsible for killing Haller inside the store on Detroit's west side received their sentences as Haller's heartbroken widow, Patricia Hower, looked on. Patricia Hower spoke directly to the woman who killed her husband, delivering a poignant and powerful statement that left the courtroom in stunned silence. Longtime court watchers noted that they had rarely, if ever, witnessed such impactful words in court. Outside the courtroom, emotions ran high as the gravity of the situation became profound.
I thank you, Lord. I thank you, Lord. Thank you, Jesus. Thank you, God.
Inside the courtroom, there was an eruption of anger as Patricia Hower delivered her statement.
I want to get her. Yes, I do, Your Honor. I want to get her. You just don't know how I want to get you. You don't know how I want to get you. Ma'am?
The wife and children of James Haller Jr. had their final say as the 2 women who pled guilty to robbing and shooting him to death inside an O'Reilly Auto Parts store last November were sentenced. Shooter Shanti Anderson received a sentence of 3 to 60 years.
You don't know what you did, young lady. Do you understand me? You don't know what you did. And I wish I could get to you to hang you in here today.
Anderson showed zero remorse during the proceedings.
I want to say that people make mistakes, and your mistakes don't define who you are as a person.
Ross received a sentence of 21 to 50 years. Haller's son also delivered a moving message during the proceedings.
If at all in my power, I'm going to make sure you spend every single year of that sentence to the maximum behind bars. And that's my goal.
I just wanted to get her, but vengeance belongs to God, not me. But at that moment, I just wanted to get her. And I know that wouldn't have been right.
Patricia Hower had one final message for the court and the woman who killed her husband. She reminded them that James Haller was a Marine who fought for his country in Vietnam. After returning, he raised a large, tight-knit family and worked a part-time job at O'Reilly Auto Parts to share his expertise in fixing cars. It was during this time that the 2 women came in and shot him to death. Her heart breaks for her family and the loss they've endured. There was also significant discussion about a 3rd suspect, Leviticus Butler, who was the getaway driver and the boyfriend of both women sentenced. Butler cooperated with police and prosecutors, testifying against the women or being willing to do so. He is currently on probation for his role in the crime. The system meant to protect children failed Ania Day Garrett, who was tragically found beaten and abused. A state agency has cited Harbor Crest Daycare in Euclid for failing to notify county child welfare workers about signs of abuse and neglect. A police report revealed more than a dozen incidents documented by Harbor Crest over the past 2.5 years. The daycare was required by law to report suspected abuse, but according to the state, that didn't happen.
They failed her.
A former worker at the daycare shared that she repeatedly saw Ania with and the child would say, "Mommy did it." Now, Ania's mother and her boyfriend have been charged with her murder. Michelle Marshall, a daycare employee, had tried to stand up to her boss, raising concerns about the child's well-being.
Did you ever report this to anyone other than Harbor Crest?
No, just only the incident, and the director would say, I filed a report. I filed a report.
Ania's father revealed that he had warned the county about his concerns, telling them his daughter was in danger. Despite his efforts, the system failed to protect her.
I did everything in my power to let them know, that I was a stand-up dad and that my daughter was being harmed and abused at home.
Meanwhile, the state has also reviewed how county child care workers handled Ania's case. The concerns go back years. These issues included inconsistencies in when county caseworkers did or didn't make face-to-face visits with families, among other concerns. The case has sparked protests, and the county has enlisted an outside panel to review it as well. The Ohio Department of Jobs and Family Services revealed that the daycare also failed to inform the state last year when Ania was taken to the hospital for her injuries. This is yet more evidence of how this little girl tragically slipped through the cracks in the system meant to protect her, ultimately leading to her death. The trial of Chad Dorman, the Clermont County father who murdered his 3 young sons, concluded with Dorman accepting a plea deal that spares him the death penalty but ensures he will spend the rest of his life in prison. While there has been public outrage over his life being spared, after the hearing, the prosecutor shared a letter from Dorman's ex-wife, Laura. She expressed her support for the plea deal in the letter, stating, "I am in full agreement with how the criminal case was resolved. The decision to end the criminal case with a plea, having a guarantee that he will spend the rest of his life behind bars, is what is best for my family." The plea deal also spares Laura and her daughter Alexis from having to testify and relive the traumatic events.
How do you plead?
Guilty. Chad Dorman repeated the word 5 times as he was convicted of 3 counts of aggravated murder and 2 counts of felonious assault. His victims were his own 3 sons, Clayton, Hunter, and Chase, whom Dorman shot and killed at their home. Dorman's ex-wife, Laura, and stepdaughter, Alexis, were also injured in the attack. They stood just feet away from Dorman as the prosecutor read their victim impact statements, detailing the heartbreaking toll of his actions.
Chad, I trusted you with my life, and honestly, I looked up to you more than anyone. I saw you as my dad, not just a stepdad, because it hurts to know I will never get to experience another day with my 3 brothers, or to make any memories anymore, because their innocent lives were taken away so quickly and horribly by their own father.
Laura's statement was deeply emotional as she described the horrific moments of trying to save her sons from her husband.
I was injured that day, fighting with every ounce of my body to just make it stop. I struggle every day, knowing I was not successful in doing so. And now I have to live with this and wonder what more I could have done to save them. I would do anything to push them on the swing, cover them up one more time, and hear their little ways of saying, "I love you."
Dorman was given the opportunity to speak, but he declined. His attorney, however, claimed that the tragedy never would have occurred if not for Dorman's delusional state and psychosis at the time of the killings. The murder at Lenox Square has now been solved, with a judge sentencing the responsible man to life without parole, longer than what the prosecution had requested. The incident occurred in 2020 and stemmed from a dispute over a parking spot. A prosecutor from the Fulton County District Attorney's Office used a large diagram of the Lenox Square parking lot, along with surveillance video and other evidence, to illustrate to the jury what happened. He noted that the incident ended in murder in the parking lot, but began as what should have been a minor disagreement over parking.
On the count of murder, I'm going to sentence you to life without the possibility of parole. This case is particularly disturbing. It was described by witnesses to the murder as an execution. It was pure evil, with a gun pointed to the back of that victim's head when you pulled the trigger and killed a man, leaving his family and his child with no father.
The law, a Lenox Square parking lot, and a life lost.
On March 8, 2020, defendant Ricky Lafargue shot and killed Twan Nguyen in the back of the head in the parking lot of Lenox Mall, all over a dispute over a parking spot.
Chief Senior Assistant Fulton County DA John Whitehour stated that he recommended a life sentence, but given James Lafargue's age at the time of the murder, 19, and his lack of an adult criminal record, he suggested life with the possibility of parole plus 5 years. However, Judge Alice Benton surpassed that recommendation, ordering a sentence of life without parole plus 5 years.
Someone lost their life over.
Fulton County DA Fonnie Willis speaks.
Your reaction to the sentence?
I'm pleased with it. I understand why the judge gave the sentence she gave.
Danielle Russell worked alongside John Whitehour in trying the case.
The judge did the right thing in this case.
Whitehour stated that an SUV carrying Lafargue and 4 others quickly pulled into a parking space that Nguyen and his girlfriend had been waiting for. An exchange of words took place between Nguyen and Lafargue's group from a distance.
Lafargue is wearing the KC hat.
Lafargue's group then went to the mall food court. Prosecutors believe that Nguyen, who was unarmed and outnumbered, must have seen them leaving and followed them out. During the confrontation, Lafargue, who had a gun in a sling bag, circled behind Thuan Nguyen and shot him. Lafargue's group fled in an SUV, but quickly crashed, and Lafargue ran off, leaving behind a gun and a hat containing his DNA.
Defense was Mr. Lafargue took out the weapon, attempted to strike the victim, and the accidentally went off. A defense which the jury evidently rejected, but that I believe will hold water on appeal.
There's no evidence that Mr. Nguyen ever threw any punches at Mr. Lafargue.
It was senseless. There were multiple people around. It was in broad daylight.
I know that we have people that are saying, well, they won't go to popular spots in Atlanta. I'm not willing to give up any of Atlanta to include Lenox Mall. We think that Lenox has taken great steps since this, but I plan to continue to shop there. I want my constituents to continue to shop there, and I'm going to work with law enforcement to make sure we keep that a safe environment.
Whitehour also pointed out that on the witness stand, Ricky Lafargue claimed that Nguyen initiated a fistfight with a Lafargue group member. That man, who pleaded guilty under the First Offender Act to making false statements to the police, also made the same claim in court. Still, none of the state's independent witnesses corroborated it. The prosecution utilized video and photos obtained during the investigation in their report. A Buffalo woman was visibly upset upon learning her fate. A judge sentenced Shawn Lewis to 25 years to life in prison for murdering her mother 13 years ago. Lewis received the maximum sentence for stabbing her mother to death in 2005, a crime she insists she did not commit.
She was my best friend. She was my strength. There's no way on earth that I could have taken her life.
A jury saw it differently. Lewis was convicted of second-degree murder during a retrial following a hung jury in July. She was arrested after cold case investigators linked new evidence to the case.
You know, the problem was that it was all circumstantial evidence. It was a tough case, and my office, I was willing to take a tough case on.
The allegations that Shawn Lewis her mother, Latifah Lewis, 40 times at their home on Orange Street created a rift within her family during her arraignment. The tension remained high in the courtroom during Lewis's sentencing.
You lied.
Lewis frequently interrupted a family friend who was delivering a victim impact statement.
She got her GED, she went and got her job, she made her life the best she could, and she was at a point in her life where she felt that it was time for her to enjoy. You didn't even know my mother. How could you say these things?
State Supreme Court Justice Christopher Burns stated that the jury reached a fair verdict in this case and sentenced Lewis to 25 years to life. She spat into the gallery as she was led out of the courtroom. Latifah Lewis's family and friends weren't surprised by Shawn Lewis's behavior, describing her as a nasty person. Her daughter-in-law mentioned that after 13 years, the sentencing provides some closure.
A little bit, but I wish I had my mother back.
Lewis has 30 days to appeal her sentence, but the district attorney expressed confidence that the right person will be imprisoned for this crime. He stated that he hoped she would spend the rest of her life behind bars. Witnesses describe a chilling and calculated plot to kill, with Earl Maxwell facing first-degree murder charges for gunning down his ex-girlfriend, Latrice Morris Dorsey, as her children looked on. The murder occurred in her Detroit home. Dorsey was shot 10 times while her daughter was in the same room and her son was in the next room. The autopsy report was introduced, revealing the brutal nature of the crime. Dorsey had dated Maxwell for about 4 years before their breakup. She had moved on and was dating someone else, which seemingly triggered Maxwell's rage. Her estranged husband testified about a few phone calls he had with Maxwell.
What did he say the first time you spoke?
When I see your wife, I'm going to kill her. The second time he called, he reiterated that he was going to hurt her.
That was 2 weeks before the murder of Avon. Maxwell's defense attorney challenged Dorsey's testimony, arguing that it conflicted with his statement to the police.
Well, no, sir. What did I just say? I said, first time I said he called back, he said he killed her. He called back 5 minutes later, told me he wasn't going to kill her, but that's what he said. He said twice he was going to kill her.
Okay, but that's not what's in your statement, is it?
Yeah, that's because, let me tell you why. That's because my wife was dead, and I'm going through my mind crazy, okay? And you guys question me. I know. Go ahead, do your thing.
Let's do this.
The prosecutor referred to another statement made by Maxwell.
In his statement, claims that he accidentally shot Ms. Dorsey 10 times. He specifically indicates that he accidentally shot her in the back of the head, in her hands, throughout her body.
The defense is focusing on the term accidentally to challenge the first-degree murder charge. They argue that one of the shots, specifically the one to the back of the head, was accidental. Despite this, Maxwell was bound over on the first-degree murder charge, with the prosecutor pointing to other statements and evidence in the case. Raw emotions filled the Tampa courtroom as a heartbroken family member pleaded with the judge to be tough on convicted killer Xavier Whitehead. Whitehead, who was convicted for the murders of 3 people, faced sentencing and asked the judge for leniency. The day of reckoning has finally come for Whitehead, who was found guilty of killing Derek Archie, Haley Stone, and Xavier Green. Family members of the victims expressed their pain and anger while the court prepared to hand down his sentence.
Every morning I wake up, my soul aches.
Haley Stone's mother, Dana Stone, expressed her deep pain from the daughter of Derek Archie as she emotionally expressed her grief in the courtroom, highlighting the deep loss and pain there is still struggling to cope with the immense void left in her life after losing her son as she continues to grieve and process just beginning, emphasizing the lasting consequences of his actions and the enduring pain felt by the victim. "Forgive you for taking my daughter," Dana Stone said, her voice filled with pain. "But I will tell you, one day you'll stand before God and you will have to answer for what you did." A 23-year-old woman has rejected a plea deal and now faces the possibility of life in prison without parole if convicted of the child neglect murder of her son. However, the case has become more complicated due to actions by jail staff, who opened mail between the defendant and her attorney and forwarded it to the police. The right of a defendant to communicate confidentially with their attorney without fear of that information being used against them is a fundamental principle of the American justice system. While everyone acknowledges that the mail was indeed opened, the dispute now centers on whether this breach should impact the case.
Which would you like to do?
I would like to go to trial.
All right, then we will do that.
Lovely Johnson rejected a plea deal that would have resulted in a minimum sentence of 15 to 25 years. Now, she's risking her fate with a jury, which could potentially sentence her to life in prison. While Johnson was in jail earlier this summer awaiting trial, jail staff opened a letter she wrote to her attorney, copied it, and then sent it to the Wyoming police.
The last thing we want to do is violate anyone's rights, and by breaching that attorney-client privilege, we are doing that.
Jail officials claim the letter was opened by mistake, and Wyoming police stated that as soon as they received it, they forwarded it unread to the Kent County prosecutor. The prosecutor also confirmed it was not read, and the matter was brought to the attention of Judge Mark Trusock.
This is not to happen again out at the jail, or there will be contempt issues.
Jail staff routinely open all incoming mail to check for weapons or drugs. When requested by the prosecutor, they may copy and save the contents. However, this procedure is not meant to apply to legal mail, which is supposed to remain confidential between the defendant and their attorney.
Because mail is one of the several tasks that our staff are responsible for, I can't identify which of the 5 property clerks could have been involved in this situation.
The defense requested more time to prepare in court, but the judge denied the request.
I would say it's almost
insane to say that we can't even have a week or 2 weeks to find out was it appropriate what happened with her letters to me.
Schildgen stated that he believes this isn't the only case where confidential mail was improperly handled. He suspects it also occurred in the case of Quinn James, who is accused of murdering a girl.
And if these mistakes are able to happen on 2 murder cases in less than a month, that's a problem. I'd like to see the jail do a complete investigation about how many letters were opened and copied and sent to police and prosecutors.
The jail administration says it is taking this issue seriously and has now implemented a policy requiring a supervisor to be informed when mail is copied. Meanwhile, Lovely Johnson's trial is set to begin, and regardless of the verdict, an appeal seems almost inevitable given the circumstances surrounding the mishandling of her legal mail. Deborah King has been sentenced to 15 years to life in prison for killing her father, Joel Woods, while driving under the influence. This occurred as he was picking up her son from school. In court, King dropped another bombshell, as she had done previously. She attempted to delay her sentencing, but her tactics did not succeed and outraged the victim's family. In the Salinas courtroom, Adriana Woods, Joel's wife, looked at her husband's killer, expressing her wish that King could receive the maximum sentence and hoping to come to terms with the life that was taken.
And I hope that she thinks about what she did and at some point accepts responsibility.
The wife of Joel Woods remarked that Deborah King's tactics to avoid responsibility were typical. At one point, King claimed she was insane, which delayed her trial by a year and nearly postponed her sentencing. Then, she dropped another bombshell by sending a letter to the district attorney's office, indicating that she had information about another crime and another defendant. It appeared to be an attempt to negotiate a lower sentence, but the judge rejected the letter.
Her history shows she's only thought about herself.
I don't think she ever wanted to face this day and hoped to put it off forever, but she couldn't.
She's never shown one shred of remorse except for herself.
Joel Woods' father addressed Deborah King in court, expressing his hope that she suffers every day she spends in prison. King received a sentence of 15 years to life for killing Woods nearly 3 years ago, while he was picking up his son from school. At the time of the incident, she was under the influence of prescription pain pills. Woods told the convicted killer that she did not understand what true pain is, and promised to be present when she became eligible for parole.
Well, she's got to serve at least 15 by this time her already served. That means I'll be somewhere around 80 years old, and I'll be there if I'm still alive.
She just can't ever be free to get in another car. So that will be our goal.
Deborah King may never get behind the wheel again. She was sentenced to 15 years to life in prison due to her history, which includes 6 DUI convictions. There was chaos in the courtroom when a 75-year-old killer verbally attacked the wife of the man he murdered. This outburst occurred just before the shooter found out how many years he would spend in prison for killing a man over a dispute.
I killed this kid. Check him out, Judge. Like a baby.
That's why I killed him. He cried like a baby. Those are the words Omar Rodriguez shouted at the wife of Jose Ray, the neighbor he shot and killed because of his dog.
Was your husband. You pathetic coward was your husband.
Stability and safety of an entire family.
That's why I killed him. Check him out, Judge. Like a baby.
Rodriguez had a reputation for being aggressive and difficult among his lifelong neighbors in Kendall.
The guy we saw in there yelling, is that the neighbor that you...
That's exactly who he is.
Yeah, that's exactly his behavior, and we were not expecting anything less.
Jurors convicted the 75-year-old in May for fatally shooting Ray. He was hoping for a lighter sentence from the judge, but Rodriguez was sentenced to life in prison.
Defendant is sentenced to life with a 25-year mandatory minimum term.
Ray's wife is relieved that he won't get out, but she wants a longer sentence.
I wish, though, that the death sentence would have been on the table, because at the end of the day, Mr. Rodriguez will continue to see his family. They'll be able to visit him and see him. I'll never get to see my husband again.
Regarding Rodriguez's attack on her, while she spoke about her loving husband, Lizette says she is unbothered.
I wasn't listening to exactly what he was saying. I was tuning him out. I was just reading my thoughts. His words are irrelevant. He is irrelevant in my life right now. He is pond scum.
Rodriguez's attorney was left speechless by his client's behavior. The 75-year-old was removed from the courtroom before hearing that he would spend the rest of his life in prison. In a released jail call, the killer stated that if he had to do it all over again, he would do it the same way. Prosecutors have described the murder of former Navy sailor Victor Sasato as the ultimate act of obsession. His ex-girlfriend, Vegas Bray, faced the charges in court. It was revealed that Sasato was shot 9 times, but the revolver only holds 6 bullets. This suggests that Bray may have emptied the revolver into her ex, then reloaded and continued shooting. In court, Bray appeared emotionless as she faced Sasato's family. It's been learned that the two met in the Navy, and Bray may have struggled to let him go after their breakup last year.
Tires, put paint on his door, smeared peanut butter on his door, all in an attempt to get...
The district attorney described Victor Sasato as Vegas Bray's ultimate obsession, her fatal attraction. He revealed that they had spoken, and Bray left but then returned.
She was armed with a .38 revolver as well as a box of hollow point ammunition.
His ex-fiancée, Zuli Imo Ray, said it should have been stopped sooner. He filed reports, but nothing was done about them.
Now, we all knew what she was doing. And, I mean, he would text me pictures. He would text me when she was outside. I saw her outside of his house.
You can spot the eggs on the house and the paint on the door.
But here he is showing damage to his house, physical damage at one point when she hit him with a jar of jelly, and his son was at the house. And yet, there was never enough evidence.
Bray's brother says he supports his sister.
They're portraying her to be some kind of monster, you know? Like I said, like, we don't know what really happened, we don't know the full story, and she has nothing.
Sasato's friends and family seem to have a different opinion.
Ex-girlfriend my dad.
His 6-year-old son knows what monsters are, but he still can't grasp why he has to grow up without his dad.
Dad, is this my only dad?
A pregnant girl, Morgan Martin, left her home in St. Petersburg and never returned. Jacoby Flowers, the father of her unborn child, was sentenced to 40 years in prison for her murder, but not before hearing emotional testimony from Morgan's loved ones. As part of his plea agreement, Flowers could have faced only 25 years in prison if investigators had been able to locate Morgan Martin's body before sentencing. Unfortunately, her remains were never found, and as a result, Flowers received a 40-year prison sentence.
She was my child. She was my daughter, and she was so good-hearted.
Leah Martin's emotions swung between uncontrollable grief and intense rage.
And I hope that every day that you sleep, you have to see her. Do you understand me? I hope you see her face.
Those emotions had been building for nearly a decade, and as Leah Martin stared at Jacoby Flowers in court, the man being sentenced for murdering her daughter, Morgan Martin, she could no longer hold back. The years of grief and anguish came pouring out as she confronted the man responsible for her daughter's death.
You didn't only kill my child, you killed your own. You're worthless.
When Jacoby Flowers entered the courtroom, he appeared to be smiling. Before the judge handed down the 40-year sentence, Flowers had the chance to speak from the stand.
There's not a day that goes by in the last 10 years that I haven't felt the deepest level of regret and remorse for my actions.
Jacoby Flowers led investigators to a location in Alabama where he claimed to have buried Morgan Martin's body in 2012. Authorities searched the area for several days, but were unable to find her remains. Despite the setback, St. Petersburg police have said they will not stop looking for Morgan.
Our ultimate goal is to locate Morgan Martin and to bring her home for her family. And as far as I see it, this case is not closed until that happens.
Investigators revealed that text messages between Morgan Martin and Jacoby Flowers showed signs of a troubled relationship. Detectives said Flowers begged Morgan not to have the baby as he was involved in another relationship at the time. Then, one night in 2012, Morgan left her home and never returned. Her mother, Leah Martin, finally felt some sense of relief during the trial, as she had the chance to confront her daughter's killer face to face after years of waiting for justice.
It was good for him to know that I don't forgive him. He shows no grief. He doesn't care. 40 years wasn't enough. But then again, a million years wouldn't have been enough for me.
Flowers has been behind bars for the past 6 years, so with time served, he will spend the next 34 years in prison. In In a murder case that has stunned America, a teen has confessed to strangling his mother over a bad grade.
Do you solemnly swear or affirm to tell the truth, whole truth, and nothing but the truth, so help you God?
Greg Ramos showed no emotion in court as he was prosecuted for first-degree murder. According to police, Ramos and his mother had a heated argument around midnight after he came home with a D on his report card. He allegedly snuck into her room and strangled her. Afterward, he went to get a wheelbarrow to move her body, but when he returned, he realized she was still alive. Ramos told police he strangled her again, this time taking nearly 30 minutes to end her life. Ramos was later called to the school. Friends who are accused of helping him bury his mother, 46-year-old Gail Clevenger, in a fire pit near a church outside Orlando, were also involved.
All the stones were arranged. It was a fire pit, and this is where him and his friends would always come. We did a cursory search. Unfortunately, her foot was protruding after digging down maybe 8 or 10 inches. That's not really a big place to where he put his mom.
County Sheriff Mike Chitwood described Greg Ramos as remorseless. Initially, Ramos told police that he had come home from school to find the house ransacked and his mother missing, claiming burglars had abducted her. However, officers noticed scratches on his face, leading them to take him in for questioning. It didn't take long for his story to untangle.
It was very boom, 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 boom. Normally you figure there's a point in time where somebody's going to break down or there's going to be some type of emotional. There was no emotional, nothing. There was nothing at all.
Criminologist Dr. Casey Jordan weighs in on the case.
These kids, very often we don't see the signs because they are showing no emotions at all. They are what we simply call flatline. They don't show any empathy, any sympathy, any remorse, any guilt.
A video shows Greg Ramos performing taekwondo at a martial arts camp in 2015 with his mother Gail there to cheer him on. Ramos was also part of the Police Explorers youth group and had aspirations of becoming a homicide detective. Friends describe Gail as a loving mother. Her last post was a photo of Ramos when he was 6 years old, with the caption, "Love this face." Dawn Marie, a close family friend, reflected on the tragedy.
The little boy that I knew from a young age was brought up in a loving home with loving parents, and he's not the monster they're saying he is.
Greg Ramos was sentenced to 45 years in prison for the murder of his mother, Gail Clevenger. He was convicted of first-degree murder after confessing to strangling her. In addition to the 45-year sentence, Ramos will face lifetime probation once he is released, and his case will be reviewed after 25 years to determine if any changes to his conviction are warranted. A Fresno County jury is currently reviewing evidence related to a murder that occurred in 2009. Prosecutors have charged Marcus Faulk with killing his cellmate while both were incarcerated at Pleasant Valley State Prison in Coalinga. Now, 15 years after the inmate's murder, the jury is learning about where investigators believe the suspect hid his weapon.
Once this mattress was moved outside of the cell,
prosecutors have charged Marcus Faulk with 1 count of murder in connection with the death of his cellmate, Jason Sean Cannon. Reports from 2009 indicate that Cannon, a 35-year-old from Sacramento County, was serving a 32-month sentence for resisting arrest when he was killed. Jurors heard evidence regarding a prison-made weapon that investigators discovered in Faulk's cell, hidden inside a mattress.
As I recall, it was embedded in the stuffing.
it was embedded.
Yes,
Okay.
in the center somehow.
Prosecutors claim that Faulk had a pact with another prison inmate to kill their cellmates, but Faulk denies the murder charge and has pleaded not guilty. His public defender called upon the prison's current chief of mental health, who has reviewed reports regarding Faulk's mental health diagnosis.
Did you review a record where he was diagnosed in 2007, July 16th of 2007, with bipolar disorder?
Yes, I
Okay.
did.
It has taken years to reach the evidence that attorneys are now presenting to jurors. The case has faced delays from the beginning. Prosecutors noted that Fresno County Sheriff Deputy Joel Wallenmeyer was investigating the case when he died in the line of duty in 2010. The case was subsequently filed in 2019, but as it moved through the court system, attorneys encountered additional delays due to the pandemic. The challenges of trying a case that is now over 15 years old were evident, as Dr. Bao Tren testified.
The two clinicians that were assigned to Mr. Faulk at the time have since passed away.
Prosecutors have stated that they will present more evidence before the defense can call additional witnesses to build its case. Maria Ingenza, grieving the loss of her husband while her son sits in jail charged with his murder, speaks out about her unimaginable situation. She was forced to sit in court for half an hour as she was questioned, having to relive the day her husband was killed. She recalled vividly the moment police placed handcuffs on her 21-year-old son.
Why are you doing that? And they told me your husband is under the bed.
Eugene Shambo had his preliminary hearing for the shooting and killing of his father, 68-year-old Imbai Ingenza. Henderson police reported that the incident stemmed from an argument. People who knew Eugene described him as a quiet and innocent student who may have struggled under his father's strictness. In court, Eugene's lawyer portrayed the deceased as a forceful authority figure.
He not only ran the household, he ran everyone's life that lived in the house.
Eugene's mother confirmed that portrayal, stating that her controlling husband did not allow her to drive and prohibited both her and her son from having any friends. David Adam Pate was sentenced after pleading guilty to the murder of Ricky James. Pate confessed to stabbing James multiple times behind a home in Lancaster, South Carolina, before robbing him and hiding his naked body in the woods.
Let me talk to you just a little bit, Mr. Pate. How old are you?
25.
And what's your full name?
David Adam Pate.
David Adam Pate. How far did you go to school?
I got my GED.
What's the last job you had?
Mechanic, I think.
Mechanic. Yeah. You're charged with murder. You understand what you're charged with?
Yes, sir.
And you understand that murder carries a minimum sentence of 30 years and up to life.
Yes, sir.
I ask you again, how do you wish to plead, guilty or not guilty to murder?
My brother was, as the solicitor gave me the review of what was going on in the case, he said, supposedly he said, I killed him because he came in the woods with me. And why would somebody want to talk to me looking like this? But my brother was the type of person who had no strings with nobody. Like, everybody was treated fairly with him. His only weakness was that he drunk. And when he started to drink, he started to trust people too much. But besides that, he was a good guy. Like, and I hope that you give him all he can get. Like, just let him suffer. And I'm just coming from behind an SCDC, and he gonna suffer back there. I just hope he knows he's gonna suffer back there.
This man slayed my brother for no reason. He admitted. He admitted. People like that ain't supposed to live on earth. People like that. Devils, man. You devil, man. You're gonna suffer. You're gonna suffer. Because they say God is a vengeful. You're vengeful God, boy.
Thank you, Mr. James.
As stated, he says he'd like to do it again and enjoyed what he did. Life's the only thing that makes sense here to us. I can't explain what we just heard. Even from that day, watching it again, from sitting across from him, it's, you know, you just can't explain it.
This is an evil person standing before you. And if anybody ever deserved life in prison, it's David Pate.
It appears that this murder, even yet, seems to be completely senseless, remorseless, emotionless. There is a benefit to the defendant in that he's still living. There is, you know, whoever he is, as long as he's breathing, there's still some hope for him. Since the court, as you know, indictment 2014 GS 29221, State versus David Allen Pate, having pled guilty to murder. Since the court, as he be committed to the State Department of Corrections for a determined term of life. Thank you. Please hold your emotions, your apology. You can do that outside the court.
He was sentenced to life in prison. The jury recommended 25 years in prison for the mother due to the murder of her own son, Kitten Brown. A judge finalized that sentence for Molly Schaus. While the decision didn't surprise some, the raw emotions from the prosecutor did. Attorney Erin McKenzie, known for her tough demeanor in the Commonwealth Attorney's Office, admitted that this case has taken a toll on her. As the case came to a close today after nearly a year, she couldn't hold back her emotions and expressed her exhaustion.
Kenton Brown cannot give you a victim impact statement. And there is nobody here in this courtroom from his family to give you a victim impact statement.
His mother, Molly Schaus, has been convicted of his murder. His father, Kenneth Brown, is in jail for murder in an unrelated case. Assistant Commonwealth Attorney McKenzie didn't hold back as she served as his advocate.
It falls on me to remind the court of the life that was lost, of the little boy who will never have his first day of school.
After more than a year filled with graphic and disturbing details about the boy's death, McKenzie's emotions reached their peak.
The little boy that sat in his car seat and suffered for hours upon hours, while his skin against the hot plastic of the buckle between his legs, with his little wet diaper stuck to him in the heat. There's nobody here to speak for Kenton today.
The final sentencing was up to Judge Stephen, who agreed with the jury's recommendation of 35 years.
Ms. Schaus, you chose the drugs over the life of your child. And so the court will sentence you today.
With no visible emotions, Schaus was led to prison, an outcome that brought the prosecutor to tears.
Just needed to see that for myself, to have peace with this case.
Judge Stephen also admonished Molly Schaus, stating that she showed remorse only for herself, not for the boy she was convicted of murdering. Her defense attorney attempted to reduce the 35-year sentence to 20 years, and Schaus's mother even spoke on her behalf. However, that request was denied, and she was immediately imprisoned. The maximum sentence was handed down to the man convicted of murdering and sexually abusing Ian Brooks in September 2013. Matthew Kazdal's comments in court angered both prosecutors and family members. Ian Brooks' mother was too distressed to speak in court this morning, so she submitted a statement instead. However, before the sentence was delivered, accused child killer Matthew Kazdal had a few things to say.
Acted in a reckless and unresponsible fashion. I regret it every day.
Matthew apologized for his actions that led to Ian Brooks' death, but refused to take responsibility for sexually abusing the child.
Will not and will never take responsibility for him being assaulted.
Those comments caused Ian's mother to break down in tears and angered both prosecutors and family members.
I will never forgive what he did, nor will I ever forget it.
During the trial, Matthew kept changing his story. At first, he claimed that he and Brooks had fallen downstairs, and then he changed it to say that the child hit his head when he put him in the shower. However, medical testimony revealed that Ian had been sexually assaulted and injured hours before Matthew called 911.
He hid from it, he lied about it, he tried to deceive, all indications of the type of person he is, and he got what he deserved today.
Prosecutor James Barnazzi pushed for the maximum sentence, while State Supreme Court Justice Christopher Burns reprimanded Kazdal for his actions.
And no 5-year-old child deserves to be treated with such brutality.
Justice was served when the maximum sentences were handed down for both the second-degree murder and predatory sexual assault charges. Since these sentences must be served consecutively, Matthew will spend 50 years in prison. A mother and daughter who were sentenced to over 30 years in prison for the death of a baby at their daycare are now asking for their convictions to be overturned or for a new trial. Their lawyers brought the case to the New Mexico Supreme Court, claiming that it was simply a tragic accident and the women are facing harsh punishment for it.
I know I will carry this with me every day for the rest of my life.
That was Mary Taylor at her sentencing back in March 2019. She and her daughter, Sandy, were found guilty of the death of Malia Jones and the injuries of Aubrey Loya. Prosecutors believe that in July 2017, the two little girls were left in a hot car for nearly 3 hours while at the Taylor Tots daycare in Portales. Both women apologized to the victims' families during their sentencing.
I want Erica and Kristen and all their family to know that I'm so sorry from the bottom of my heart.
The judge ended up sentencing Mary to 36 years in prison and Sandy to 30 years.
This, as the evidence presented at trial demonstrated, was a day filled with reckless disregard for the safety of the children.
The state Supreme Court heard arguments asking the justices to either overturn Mary and Sandy's convictions or grant them a new trial. Their lawyers argue that no evidence showed the women intentionally left the children in the car. They also claim that prosecutors misinterpreted the definition of child abuse by reckless disregard, which is the charge they were convicted of. The defense maintains that this was a tragic accident. These were the same points raised in the defense's closing arguments.
Ladies and gentlemen, it is not unreasonable to believe that Mary did not know what was going on. She believed the children had been inside. And something happened when Sandy was going to go fax the documents, believing that they'd only been out there for a few moments.
During the sentencing, the victim's family expressed relief and satisfaction in finally getting justice.
Like relieved to know that they are being held accountable.
The surviving child now lives with permanent brain damage. The Supreme Court justices listened to oral arguments from both sides, but they haven't decided yet. A father accused of a shocking and unimaginable crime.
Pull a baby out and you just throw this baby away like it's nothing?
The police are saying that he threw his daughter off a bridge, leading to her death.
She was my little angel baby. She always will be.
Whether they are parents or not, people everywhere are overwhelmed with sadness and anger, stunned by Jonchuck's alleged actions. The tragic event took place at the top of the Dick Meisner Bridge, near the Sunshine Skyway. A St. Pete police officer was just a few feet away, unable to prevent the horrific act. After the officer witnessed the child fall 60 feet into the water from the bridge, Jonchuck was arrested and charged with first-degree murder, fleeing from the police, and even attempting to run over an officer. Questions are being raised about Jonchuck's mental state. During his first court appearance, he told the judge that he did not want a lawyer to be appointed to represent him.
I want to leave it in the hands of God.
Pretty sure God's not going to be representing you in this case, and you're going to be standing trial.
Circuit Judge Michael Andrews granted the 25-year-old a second chance.
Would you like someone standing next to you as you're standing trial?
Yeah.
An attorney.
That is pure and good, not evil.
Well, I'm going to do the best I can to give you a pure and good lawyer.
Jonchuck was ordered to undergo a mental evaluation. St. Petersburg police reported that an officer witnessed Jonchuck throw his daughter off the Meisner Bridge.
Been doing this job for 29 years, and I don't even know what was going through this guy's mind.
Jonchuck had been speeding just before reaching the Sunshine Skyway. He came to a stop, and as he initially approached an officer, Jonchuck suddenly turned back and headed toward his car.
And then you go to your driver's side of the car and you pull a baby out, and you just throw this baby away like it's nothing.
Phoebe Jonchuck fell more than 60 feet from the bridge. Police say it's still unclear whether she was alive before being dropped, but divers found her body an hour and a half later. After the incident, Jonchuck fled the scene, driving the wrong way near University Parkway, where he was eventually caught. He refused to answer any questions about what had happened. Meanwhile, the officer who witnessed the tragic fall climbed a ladder, desperately hoping to find Phoebe, but she had disappeared into the darkness.
Most of us can probably imagine having gone through something like this and witnessing what he witnessed last night. It's beyond imagination.
St. Petersburg police have not released the officer's name in this case. He was sent home and will be offered counseling if needed. Meanwhile, the investigation continues as authorities try to determine exactly what was happening with the girl at the moment she was thrown from the bridge and whether she was still alive at that time. After spending nearly 6 years in the Bexar County Jail, a suspect in 2 capital murder cases has finally been given a trial date. Jose Baldomero Flores was arrested in 2016 in connection with 2 separate cold cases. He is charged with the 2005 murder of Heather Williams, who was found dead in her Leon Valley apartment, and the 2011 murder of Esmeralda Herrera, whose apartment Flores allegedly burned down.
For the record, Mr. Flores has been in jail, according to this docket at the time of the printing of this docket, 1,918 days.
37th District Court Judge Melissa Skinner has ordered that this case go to trial, noting that it is one of the oldest cases in her court.
I would like to find out what your prospective schedule is, because I'm looking at the summer.
The 2 murder cases remained unsolved until 2016, when investigators connected evidence from the 2 crime scenes to individuals who knew both women. Since then, there have been numerous hearings regarding the cases. The trial appeared close to starting in 2020, but the pandemic delayed proceedings. A scheduling order has been established, with jury selection set for July 29th and the trial beginning September 5th. This September 5th trial date will specifically address the 2011 murder case, where prosecutors will be seeking the death penalty. Security experts are warning parents following the shutdown of a local school district. Meanwhile, a notorious figure from Washington's past, the Green River killer Gary Ridgeway, has resurfaced. Ridgeway, who terrorized Washington for years and pleaded guilty to the murders of dozens of women in King County, leaving many families grieving, is back in the spotlight. Although he's been in prison for decades, records show Ridgeway was booked into the King County Jail at 10:42 p.m. after being transported from the Washington State Penitentiary in Walla Walla. According to the King County Prosecuting Attorney's Office, Ridgeway hasn't been charged with anything new, but is being held under an institutional order. No further details about why he's back in King County have been released. When contacted, the King County Sheriff's Office issued a statement saying, "Since Gary Ridgeway's arrest in 2001 related to the Green River murder investigation, the King County Sheriff's Office continues to investigate potentially related cases actively. While his current location is precise, the reason for his return to this side of the state remains a mystery."
There's a lot of rich information that bad guys can mine, so they really are kind of a easy target.
A Marion County man, Michael Jones, admitted to killing his family and was sentenced for their murder.
Top of the show, sentencing had begun for the Marion County man who admitted to killing his family. We now know he'll face the death penalty. Michael Jones pleaded guilty to killing his wife and 4 children in 2019. A judge gave him a life sentence for the death of his wife, but gave him the death penalty for the 4 children.
A judge handed down a life sentence for the death of his wife, but imposed the death penalty for the murders of the 4 children. On March 6, 2013, Stefan Roby killed his mother and younger sister in Saginaw and was subsequently convicted. The jury carefully examined the details of the case before delivering their verdict.
Each count, the title of each count, and what your verdict is, please.
Count number 1, first degree premeditated murder of Charlotte Vanessa King. Guilty of first degree premeditated murder of Charlotte Vanessa King. Count number 2, possession of firearm at time of commission or attempted commission of felony firearm, first degree premeditated murder, count 1. Guilty of first degree premeditated murder of Lee Andrea King. Guilty of first degree premeditated murder of Lee Andrea King. Count number 4, felony firearm, first degree premeditated murder, count 3. Guilty. A felony firearm, first degree premeditated murder. Count number 5, felony possession.
Responsible for the deaths of 2 of the most vulnerable, non-threatening people in his life, his mother and his sister. And nothing was injured during his trial in his defense that led our family to believe otherwise. But in spite of this terrible crime, his mother would still want him to receive the mental health treatment that he so adamantly rejected in the past.
And I feel as though that most of my emotions didn't get back because you were distracted.
Well, that is totally untrue.
Well, when she was on the stand, your phone kept going off a couple times, and you kept asking her, was it her phone? When I came into the courtroom, I see you on the phone.
Not while the court was in session.
Okay, but your phone was still going off and you were still distracted by the phone.
No, that is untrue. That is totally untrue. And that has nothing to do with the sentence.
Yes, it does have something to do with it.
Do you have anything you want to tell me in regards to this sentence?
Yes, I want to vote on mistrial because I don't...
Denied. Anything else?
No.
This is one of the most egregious cases I've ever had. When your mother,
don't worry about what I...
the woman that brought you into this world, and your sister, and you're going to spend the rest of your natural life in prison. Hopefully someday you'll think about that. Get him out of here. I'm done.
He was sentenced to life without the possibility of parole. Antoana Smith is charged with Trayvon Tabor Lesson's murder and appeared before a judge for the first time. In court, several major developments emerged. It was revealed that there might be surveillance video of the entire incident, which could provide crucial details about the moment Trayonte Burleson was shot and killed.
State of Tennessee versus Antoana Smith.
18-year-old Antoana Smith, wearing a jumpsuit and handcuffs, appeared in court. This marked the beginning of the legal process in which she is now involved.
You're going to tell the truth about what happened?
Yes, ma'am.
Okay.
Most of the witnesses in this case are too young to be shown on television.
They weren't going to stop it till they, fought us and stuff, so we was like, just let's get it over with. We ain't gonna bring it to Facebook.
She testified in court about how, on November 3rd, she had been with Trayonte Burleson near J.C. Napier's home. At some point, Antoana Smith confronted them over a fight that had taken place on social media.
You told the defendant, Miss Smith, to put her gun down?
Yes, ma'am.
How was she holding the gun when you said that?
It was in her right pocket, and she was just holding it she was clutching on it.
Prosecutors say that Antoana then turned the gun on Trayonte and fired. The boy died on the way to the hospital.
We knew she had a gun and everything, but we ain't thinking she ain't gonna use it. But
did she agree to speak with you?
Yes, ma'am.
Detective Travis Zander was the first person to interview Antoana after the shooting.
Just said, I shot the girl, and she retreated back into the apartment at that time and shut the door behind her.
It is a case that has shattered two lives.
See the picture right here. She was 14. She looked like a bad child. She looked like she deserved to be. No.
It is just the beginning of a legal process that no teenager should have to endure. As crime rates soared in Albuquerque, Miranda Gilbert symbolized the growing problem. The video of her shooting at a couple on their way to church sparked widespread outrage. She learned that she'd be spending a long time in prison. In court, Miranda appeared very different from the person she was last year, saying she'd had a harsh wake-up call. The couple she shot at hopes she truly means it. She was sentenced to 15 years in federal prison.
Justice was served today, and that's what we came to see. We need that.
Miranda Gilbert threatened Bill and Carolyn Thompson with a gun after they found her in their driveway, likely scoping out their home. Gilbert fired a shot that nearly hit Carolyn, leaving the couple traumatized for life.
Sometimes you don't realize how traumatic something like this is, but it is.
Miranda Gilbert was arrested the day after the shooting, following a chase with U.S. Marshals, during which she tried to ram one of their vehicles. In May, she pled guilty to being a felon in possession of a gun and for assaulting a federal officer. In federal court, the 31-year-old mother of four tearfully asked for forgiveness from the couple she shot at and expressed remorse for her actions. She admitted that drugs had destroyed her life, but claimed she was in a much better place now. In a surprising act of compassion, the Thompsons offered to help her once she completed her sentence.
We can forgive people. We believe in justice. We believe they need to pay for what they do. We're also willing to help them.
Gilbert's family was also present in court, and they broke down in tears when the judge announced her sentence. However, it wasn't the outcome the Thompsons had hoped for.
And being a repeater offender, I just think they need to be kept behind bars. They don't need to be out. But that's my opinion. The judge has more experience at it, so I'm going to go by his choice on this, I guess.
In court, Gilbert insisted that the gun went off accidentally. She is set to be released from prison in 2033. Before this case, Gilbert had 10 previous convictions, ranging from burglary and car theft to dealing heroin. The district attorney's office had the option to pursue a longer sentence by trying her for the actual shooting, but decided against it. The abuse Glenora Bates endured at the hands of her parents left many shocked. Nearly 3 years ago, a woman arrived at Children's Hospital with her severely malnourished daughter, who was already dead. Glenaira's mother, Andrea Bradley, accepted a plea deal in her daughter's death. Bradley had initially been charged with aggravated murder, but due to her IQ being in the 60s, the court ruled she couldn't face the death penalty. As part of the plea deal, the aggravated murder charge was dropped, and Bradley pleaded no contest to other charges. Appearing somewhat dazed and occasionally sleepy, Andrea Bradley entered a no contest plea to charges of murder and child endangerment in the death of her daughter, Glenora Bates.
You're Andrea Bradley?
Yeah.
And you accept this plea bargain, and you understand the plea bargain and the charges?
Yes.
Bradley's acceptance of the plea deal slowly brings her tragic case to a close.
The defendant, Andrea Bradley, recklessly abused Glenora Bates, her daughter.
The abuse inflicted upon Glenora Bates was unimaginable. Glenora and her siblings had previously been removed from the home, but were later returned, a decision that had tragic consequences. Her death prompted several social workers to resign, and 2 supervisors were suspended.
You do have to accept the reality that there are just some people that should never have kids, period. And our challenge is, under the federal and state guidelines that want us to reunite families, is to identify the people that shouldn't be parents and get them out of the house.
Several recommendations were made following a review of Hamilton County Job and Family Services. A spokesperson mentioned that many changes were implemented within the agency, and there had been numerous vacancies at the time of Glenora Bates's death. JFS took steps to address those vacancies, and by late 2016, the agency received approval to fill 60 new positions, with efforts to strengthen staffing still ongoing. In the trial of Glenn Bates, a jury found him guilty of aggravated murder, and the judge sentenced him to death for his role in his daughter's tragic death. This is the trial of Corey Binderim, a Clay County contractor accused of killing a client. Prosecutors allege that Binderim killed Susan in 2019. They claim he killed Malden after she demanded a refund of part of the $12,000 she had paid him for a bathroom job that was never completed. Malden had warned Binderim that if he didn't return her money, she would involve the police and seek legal action. Prosecutors argue that this ultimatum led Binderim to murder her. They assert that Binderim was the last person to see Malden alive, and that surveillance video exists showing his actions that day. The video allegedly captures him purchasing a bag and concrete before he disposed of over 300 pounds of demolition debris at a landfill. A woman who considered Malden her best friend testified that Malden had informed her about the ultimatum and that she returned to check on her friend but couldn't find her.
I kept trying to call her and then couldn't reach her that day. So then the next day then, on Friday, I told my husband, I'm going to go, if I can't reach Sue this morning, I'm going to go down to her house because, maybe she's sick or something, and then I couldn't reach her because it was very uncommon for her not to answer her phone.
The medical examiner confirmed that Malden was strangled and found evidence of a struggle. Prosecutors noted that Binderim had scratches on his arm and hand. However, Binderim's attorney argued that the case is circumstantial. The defense contends that Binderim wouldn't have had enough time to kill Malden and clean up afterward, based on the surveillance video evidence. They also stated that the items he purchased were typical for his work as a contractor.
At the end of this case, we will ask you to determine murder or not guilty to all counts, because there is reasonable doubt in this case, based on that theory.
The trial will resume soon, and we will return to the courtroom. The state is seeking the death penalty in this case. Convicted cop killer Marco Perez will soon be on Alabama's death row. The jury, who found him guilty of capital murder, sentenced him to death. The vote was 11-1 in favor of the death penalty for Perez, who killed mobile police officer Sean Tudor in 2019. After 8 days of testimony and securing the conviction, prosecutors presented more evidence to convince the jury that Perez should face the death penalty. The defense, on the other hand, asked the jury to take into account that Perez was just 19 years old when the crime happened. Mobile County DA Keith Blackwood said the verdict shows that killing law enforcement officers will not be tolerated. Defense attorney Dennis Knisley shared that the Perez family is disappointed with the outcome.
Sean Tudor put that badge on to protect and serve this community, and for it, he got sentenced to death by Marco Perez. We cannot tolerate that in our community. and we will not. Our police are vital to civilization.
Of course, they're devastated. You saw Mr. and Mrs. Perez in there. They're good people. They're hardworking people. They had a young kid, 19 years old, that went astray.
Knisely also mentioned that there are several reasons to appeal the case. In a related development, Perez's attorney, in a federal case, has filed a petition asking the U.S. Supreme Court to review that appeal. Life in prison without the possibility of parole is the sentence a serial killer received for 2 murders in St. Louis County. In the St. Louis County Circuit Courtroom, Tyler Terry pleaded guilty to murdering 71-year-old Barbara Goodkin and 58-year-old Sergei Zakharev on May 15, 2021, a date that changed many lives forever.
Pursuant to negotiations with 4 different counties, 2 in South Carolina, as well as Nashville, in an agreement pursuant with those other jurisdictions, the court sentenced Terry to life in prison without possibility of parole and multiple life sentences, all to be run consecutively.
Surrounded by members of the major case squad, St. Louis County prosecuting attorney Wesley Bell thanked the district attorneys from Chester County, South Carolina, and Tennessee for their assistance. Inside the courtroom, Stanley Goodkin, the widower of Barbara Goodkin, told Terry, "You are a worthless piece of crap and should be sentenced to a slow, burning, torturous death." Alex Zakharev, the brother of Sergei Zakharev, expressed that Sergei was a doctor who saved lives every day, adding, "I'm glad you're going to die in prison."
This heinous crime gripped the St. Louis metropolitan area, that people were just coming home from dinner and they were assaulted over on Delmar Boulevard. And Dr. Zakharev, he was just getting off an airplane coming back from Florida and was just minding his business.
Retired Olivet Police Chief Rick Knox credited the multi-jurisdictional efforts that led to the capture of Tyler Terry and Adrian Simpson. Simpson has been charged as an accomplice, and Knox stated he expects progress in her court case proceedings within the next month. 2 men have been sentenced to spend the rest of their lives in prison for the murder of a baby. Before the judge delivered the harsh sentence, the victim's father had a powerful message for the killers of his little girl.
I would like to say he's a real coward. Because you know, just like I know who shot you, but you was too busy chasing a thought. Too busy chasing a thought, and look where it got you. Going to prison, you don't know how to fight. Ain't no guns in there, you don't know how to make no knife.
Her father's understandable anger was directed at Raphael Hurd, who was sitting just feet away. Prosecutors say Hurd, driven by a desire for revenge against Kenneth French, devised a plan that tragically resulted in French's daughter, Camilla, being killed by a brutal gunshot wound to the head.
Do yourself a favor, nigga, and kill yourself. Because the world not gonna miss you. Don't nobody care about you. Don't nobody love you. Just know, when that blade penetrate that skin, cause them dudes up there waiting on you, think about me and my baby and my cousin.
Hurd was the one who sat in the getaway car that day. Prosecutors say he convinced Raymond Jackson to approach Kenneth French and the children outside their Inkster apartment and open fire. Camilla was killed, and her father, Kenneth French, along with a cousin, were wounded. The motive stemmed from a long-standing feud. Hurd had been shot 3 months earlier outside an after-hours club and blamed Camilla's father, who had been working security, for not protecting him.
A coward, and you is weak, and you call yourself a man, and you couldn't even take care of it yourself. You will never know how I feel. You will never know what I go through. And you have a great life as well. Thank you.
I would like to apologize. I swear I had no intention to harm Mr. French, Ms. Lancaster, or Kamaya.
None of this was supposed to happen. And my deepest apologies to the Gross family.
He was smiling while he was saying he apologized, so it wasn't sincere and it wasn't deep.
Jackson and Hurd each received 30 to 45 years for assault, with intent to murder Camilla's father and cousin. However, with their convictions for first-degree murder in the killing of Camilla, Both men are set to spend the rest of their lives in prison. The man accused of helping his son hide the bodies of a pregnant couple, Ramon Preciado, appeared in court, requesting a judge to lower his $600,000 bond for 2 charges. Preciado took the stand. The judge agreed to a slight reduction for one of the bonds, lowering the $500,000 bond for the charge of altering, destroying, or concealing evidence to $350,000. However, Preciado's attorney hoped to reduce it to $100,000. The bond for the charge of abuse of a corpse, set at $100,000, was requested to be reduced to $20,000, but the judge denied that request. During the hearing, Preciado cited inadequate medical care in jail and his cooperation with probation officers in the past as reasons he should be allowed to be released while awaiting trial. He is accused of helping his son, Christopher, hide the bodies of Savannah Soto and Matthew Guerra after his son allegedly shot and killed them during a drug deal. Preciado referred to himself as a good man and expressed his desire to make things right.
When a man changes who he is, he does things right. Things happen and you have to deal with it. And here we are dealing with it. But like the judges here, I'm here to do right. And I ain't going nowhere because my family's sitting in Bear County, let me tell you. And we're going to get through this because that's all I know how to do is survive. And believe me, we will get through this.
If Preciado can post bond, he would be placed under house arrest and required to stay away from the victims' families. The bond for Preciado's wife, who is also accused of helping to hide the couple's bodies, was reduced. However, she remains in the Bexar County Jail. The Oklahoma Department of Corrections is investigating after Amber Hilberling was found dead in her prison cell. Hilberling gained national attention after being convicted for pushing her husband out of their Tulsa apartment. Just 3 years ago, she was sentenced to 25 years for second-degree murder after prosecutors said she pushed her husband, Josh Hilberling, from the 25th floor of their apartment in 2011. At the time, Hilberling, who was pregnant, claimed the push occurred during an argument and that she never intended to kill him. The Department of Corrections reported that Hilberling was pronounced dead yesterday afternoon at the Mabel Bassett Correctional Center. Her defense attorney, Clark Brewster, shared that prison officials had contacted her mother to inform her of the tragic news, leaving the family devastated. A grandmother sat quietly, seemingly in shock, after being found guilty of killing her grandson. The verdict was reached after the jury's first full day of discussions. The jury didn't believe Sandra Lane's claim that she shot her grandson in self-defense. Many people thought she wouldn't be convicted of murder, especially not first or second degree, but others pointed to the 6 shots fired, suggesting it may have been planned. That's what the prosecutors argued, and in the end, the jury decided on second-degree murder. Jonathan Hoffman's parents explained why Jonathan was living with his grandmother and her husband while they were in Arizona. Part of the reason was that Jonathan wanted to finish high school in Michigan with his friends. Jonathan's mother, Jennifer, no longer considers Sandra Lane as her mother.
Well, I would prefer to call her a monster, but that's it.
Count 1, first-degree murder. Guilty of the lesser offense, second-degree murder. Count 2, possession of a firearm in the commission of a felony. Guilty of possession of a firearm in the commission of a felony.
I'm just glad that she's put away and she can't do harm to anybody else.
How would you have described Sandra Lane before all this?
She was always a thorn in my side, to be very honest. She was very difficult, very meddlesome, very controlling, and I never liked her.
She's devastated, as any 73-year-old woman might be. She's upset that, the jury found her responsible and guilty for second-degree murder.
The verdict?
Well, we're pleased that the jury reached the verdict of murder in this case. It was a very emotional case for the victim's family and all involved.
Sandra Lane was really trying to get me to send him back, and she said she would take good care of him, and she promised she would take good care of him and that he would be happy staying there with his friends and finishing out his last year of high school. And she never ever once told me that there were issues.
When we released John to her, first of all, it was very reluctantly on my part. I never wanted him to leave Arizona. Nobody knows that, but we had a situation with my daughter, She had a brain tumor, and we've had 4 surgeries, and we've been sort of tied up taking care of her, and we still are, and she's doing wonderfully well, thank you very much, under the circumstances. But I thought we should have stayed together as a family. And he thought otherwise. And to some extent, I think John was allowing us to focus our energies exclusively on Jessica.
Sandra Lane was taken back into custody by deputies. Her sentencing is set for next month, and prosecutors believe she'll face a minimum of 14 years in prison. Jennifer Hoffman, Sandra's daughter, said she would stay with them several days each month to visit her son, mother, and stepfather. She mentioned that nothing seemed wrong during her visits. They knew Jonathan had issues, including problems with mushrooms and a drug incident from back in March. She also revealed that on the day of the incident, despite being described as out of control, it was Jonathan who called 911 because of his reaction to the drugs. Jennifer and her ex-husband, Mr. Hoffman, believe their son's character has been unfairly attacked during the trial. They said he was just a typical teenager going through tough times. They also expressed their deep gratitude to the prosecutors and police for their hard work, something they hadn't been able to say before because of the ongoing trial. They feel they owe a debt of thanks to everyone involved, which they can never fully repay. There are now 10 men on Connecticut's death row, with one more added to that number. 49-year-old Richard Roskowski was sentenced for a 2006 triple murder in Bridgeport. Despite Connecticut repealing the death penalty 2 years ago, Roskowski was still sentenced to death under the old law. Connecticut has 2 capital felony laws, the old one, which still applies in this case, and the new one. Roskowski was sentenced to life in prison for the murders of his former girlfriend, Holly Flannery, and 38-year-old Thomas Godet, whom he wrongly believed was romantically involved with Holly. However, he received the death penalty for the murder of Holly's daughter, Kylie.
Our hearts break every time one of Kylie's would-be milestones happen. A life never lived. It's all too sad, and it should have never happened.
In my heart, I know Holly and Kylie's fears are gone because they are at peace with God. So for Mr. Rakowski, I want that same fear to stay with him as he sits in his little room, waiting to die, but also knowing that his will be with him for eternity in hell.
Judge John Blowy scheduled Richard Roskowski's execution for October 1st, but this is a formality. There is an automatic appeal process in place, and these appeals can extend for many years, making the execution date far from certain.
I'm truly, deeply remorseful for what happened, and I'm truly, deeply sorry for the pain that I have caused to you and to all the family members.
The reason Roskowski received the death penalty is that his crime was committed before the death penalty was repealed 2 years ago. When the legislature passed the repeal, they made it prospective, meaning it only applied to future crimes. This was explicitly done to ensure it wouldn't apply to those already convicted, like the 2 men responsible for the 2007 Cheshire home invasion murders. Without this provision, the repeal likely wouldn't have passed. However, the state Supreme Court is now reviewing whether this distinction conflicts with and violates the constitutional rights of the men currently on death row. A boy accused of murdering his mother appeared back in court. For the first time, his confession to detectives was revealed in court.
I grabbed one of the kitchen knives and then I went to her room and then it's okay, you can say she killed her.
The court played a chilling interrogation video showing Derek Rose allegedly confessing to the of his mother, Irina Garcia. In the video, Rose admitted he had considered killing himself afterward, but ultimately changed his mind. Family members in the gallery were left sobbing as they listened to the heartbreaking confession.
Mom was sleeping? Yeah, she was sleeping.
Surveillance stills released by the state attorney's office show what appears to be the teen, Derek Rose, standing over his mother's bed while gripping a knife.
Did you tell her anything before you were in Spanish?
Were there wounds to her face?
The homicide detective in this case described not only the 46 inflicted on the victim, but also detailed Derek Rose's reported actions leading up to the brutal crime.
Yes, on October 12 at 6 p.m., he did make searches on Google.
Okay.
He typed in the word, the carotid artery image diagram. What is the best place to stab someone? Is a small knife good for killing?
This hearing is being held to determine whether Derek Rose should be held as a juvenile while he awaits trial. A corrections corporal testified that due to Rose being a high-profile inmate, he is kept alone in his cell and supervised 24 hours a day. A psychologist noted that Rose has ADHD and that another doctor tested him for being on the autism spectrum. Additionally, it was revealed that Rose was suicidal when he was first brought in. A bond was revoked, and new evidence was revealed in the case of a girl who police say was shot and killed by her father. According to police, Sympathy Batts failed his first drug test just 2 to 3 days after initially being released on bond. Judge James Hunter stated that the failed test violated their bond agreement, leading to its revocation. During the court session, new details emerged as officers testified. Detective Neil Harris from the Hendersonville Police Department explained that there was a bullet hole in the wall and blood in the master bedroom. He obtained in-home security footage with 4 clips. In one of the clips, police say you can see Tamia Batts jumping up and down as if she had been shot. Her father then picks her up and runs out the front door with her. While Detective Neil Harris testified about the video, Batts was seen moving back and forth in his chair.
That Mr. Batts arrives home. He comes inside, he's talking on his cell phone, and he has a gun in his hand at that time. He walks in the direction of the master bedroom, and 5 minutes later, there's a video that shows Tamia coming home from school. She walks in, appears to be perfectly fine at that time.
After his bond was revoked, Timothy Batts, along with his aunt and father, declined to comment. He is expected to be back in court. This is the home of Linda Kasuda Bagazzi on Smith Lane in Burlington, the same place where she bludgeoned her husband to death with a hammer in 2017. After the murder, she wrapped his decomposing body in a rug and left it in the basement. Police returned to the home and discovered another body.
I order transfer to body into prison.
The last time Linda Kasuda Bagazzi appeared in court was in March. The 76-year-old had pleaded guilty to killing her husband, a health professor, in 2017. After the murder, she continued to collect his paychecks.
It was like a kick in the gut.
Bonnie O'Neill, who lives across the street, has been closely following the developments in the case.
I wasn't expecting, really, that she would kill herself.
Bonnie O'Neill watched as state police arrived in her normally quiet Smith Lane neighborhood in Burlington around 11 a.m. It was the same day Linda Kasuda Bagazzi was scheduled to be sentenced for her crime in court.
Yes, we wanted her to be punished if she truly did this, which she admitted to.
Linda was facing a 13-year prison sentence. However, state police confirmed that the body they found inside the home this time was Linda's.
If I was walking down to get the mail, she would turn around and go back to the house until I got the mail and came in. So there was no interaction after the fact.
Neighbors shared that since Linda was released on bail, several frightened families moved out of the neighborhood. Bonnie, her neighbor, said she has no doubt in her mind that Linda killed her husband.
He seemed to be the domineering one, that he was a quieter, like a little Italian man. I'm sorry, but that's, yeah. But she was opinionated.
In a statement, Linda's attorney described her as a very independent woman who was always in control of her own destiny. Her husband, Pierluigi Bagazzi, was 84 years old when he was killed in 2017. State police have not yet disclosed the manner of Linda's death, leaving it to the Office of the Chief Medical Examiner to determine the exact cause. This case revolves around Jacob Bumpass. In September 2010, in Ohio, Paige Johnson disappeared without a trace. After her body was found, the officers linked Jacob Bumpass to her disappearance. Often, family members harbor growing animosity toward the person who caused them pain.
So I would like to start with a quote by Martin Luther King, and that is, "Justice denied anywhere diminishes justice everywhere." I have another quote that I like, and that is, "When we lose someone we love, we must learn not to live without them, but to live with the love they left behind." So I wrote this out. I'm going to read it and then, just kind of go on with it. So September 23rd of 2010, that date changed the trajectory of my life indefinitely. From this day forward, things would never be the same. Life and all it entailed would immediately become dark and full of pain and anxiety. When pondering on how I would even bring myself to write this statement, a lot of emotions began to surface. How does one truly elucidate the anguish and suffering behind an entire family for the past 13 years of their life? No amount of words spoken or tears cried could truly encompass the deep, raw, and real sadness behind this loss. Paige was a vibrant, free-spirited, beautiful 17-year-old girl. She loved life and all the people in it. She viewed life through a rose-colored lens and offered trust to people who did not deserve it, an ounce of it. Paige loved to sing loudly in the car with the windows down in the summer months and the same volume in the winter months too, but with the windows up. Music so loud you will be forced to dance. I believe she danced before she ever even walked and remained dancing every chance she got until the day she died. She got that honest from her dad. Which leads me to my next mournful thought. Our father passed away back in 2017, with Paige still a missing and endangered teenager. She had been missing for 7 long years at this point, with no clues or solid leads or ideals as to where she may have been. Our dad died from a broken heart. Just a short time after his passing, our grandmother, his mother, also passed. And just like him, we know her death was the direct result of a broken heart. For nearly 10 years, I would wake at night feeling terrified by yet another lucid and disturbing dream. And I'm going to not read what I had initially wrote because it is just too graphic. But to sum it up, I would have these dreams all the time about my sister being torn apart by animals in the woods. And this is not something that you can get out of your head. It just plays and plays and plays and plays and plays. Many times I would wake just drenched in sweat to the point of becoming physically ill because the nightmares and the dreams were so real. And like I said, this is not something that can be controlled or changed or stopped. It just has become the normal pattern of sleep for years. Paige left behind a daughter who was 2 years old when this happened. She has little to no memories of her mom, and she has to live the rest of her life without knowing a mother's true unconditional love. She'll never have. And she's struggling right now as a result of that. My mother and her depression and the toll that it has taken on our entire family is immeasurable. This has kept my siblings within the confines of poverty and the anxiety having been passed down to my younger siblings who now struggle in a world that is hard to understand. My mother has become so paralyzed by the grief that there have been so many times, especially in the first 5 years, where she could not move from the bed for weeks, even months, unless forced by my grandmother to shower and eat. This takes a toll on a person and an entire family just having to witness this alone. Well, just, you know, there really is no word for it. Just constant crying and just, I don't have words really. It is unexplainable and it is unimaginable unless you've dealt with it yourself. You could probably never really grasp the depth of it. As for my grandmother, who played a major role in mine and my sister's lives, this has affected her in ways that words can also not, I can't articulate it. Seeing her child, my mother, go through this, and all of us, and then her being the backbone of our family. She would hang posters until her hands would bleed and then go to work all day long. And then get up and do it again, to the point where Covington police were telling her, like, you have to stop, this is private property or this and that. Her car was covered from top to bottom with Paige's poster. She was in over the Rhine in ghettos with no fear, just hanging posters relentlessly. And as for the defendant, I continue to be astonished, angry, frustrated, and shocked at the 100% lack of remorse and accountability. For years, he and his family, I know they have TVs, and I know that they have seen us beg and plead and cry and grieve and just for something, for just tell us where she is. Never so much as, nothing ever. I can't even wrap my mind around it. It takes a sick individual to do what the defendant has done and to carry on with his life as if it never happened. And then today is just another slap in the face to not even say that he is sorry for our loss. I was expecting, considering this is somebody who is supposed to be a friend of my sister's, you're not even sorry for the loss of her? Well, of course you're not, because you're responsible. The lack of compassion is just, it's disgusting. It's vile. And the fact that he has escaped this accountability for all of these years. And I also just wanted to speak on, I know there was something at some point, there was a remark made about our TV appearances as if they were some sort of sport, and that couldn't be further from the truth. It was, and it still is, a painful encounter each and every time. It's not something that's enjoyable to get on there and be vulnerable, begging somebody to tell you where your loved one is. So I would like to end this with another quote. I wanted to, actually, one more thing before I do that. As far as forgiveness goes, I'm going to leave that to God. I find it hard to, and I'm a Christian, but I find it hard to even hold that space in my heart for any sort of forgiveness when there has been no acknowledgement, no remorse ever. So, and I will talk with God about that on the day that I meet him. If I'm wrong for that, I'm sorry, but I just cannot even go there. And I will end with this. This is another quote from Martin Luther King Jr. It may be true that the law cannot change the heart, but it can restrain the heartless. Thank you.
After carefully reviewing every aspect of the case, the judge imposed a sentence appropriate for such heinous crimes.
Identifying what I've reviewed, certainly the pre-sentence investigative report, victim impact statement, letters that have been received from family members. Looking at the purposes and principles of sentencing, first thing I have to look at is Mr. Bumpus's prior criminal contacts, if any, and he does have criminal contacts as an adult. Back in 2007, he was convicted of theft by unlawful taking in Kenton County, Kentucky. Ultimately, it appears that he was convicted of that offense in 2007. In December of 2007, there was a robbery offense, which was reduced down to a theft by unlawful taking, and he was sent to prison in Kentucky. So that's the first Department of Corrections number he has. So he served a prison term previously on that. And in 2008, November of 2008, another theft by unlawful taking charge where he was incarcerated in Kentucky prison on that as well. So the record reflects two separate prison numbers, two separate prison stints for Mr. Bumpus. So he's committed prior criminal acts and he served prior prison terms. The court has to look at the offenses to determine whether they are the seriousness level of them. Not obviously any felony is serious, but the legality of, there's a legal terminology, if you will, in regards to seriousness factors. Statutory language that the legislature gives us, there's certain factors the court has to look at to see if an offense is more or less serious than conduct normally constituting the offense, or offenses that typically occur. As far as serious factors under 29-29-12, after reviewing those, the court is going to find that the offense, certainly both offenses, in my opinion, are more serious than conduct normally constituting the offense. One of the factors is certainly relationship that you had with the victim here facilitated the offense. This is someone that you were friends with at the time of the commission of the offenses, that trusted you, and your relationship facilitated the offenses in the court's opinion. Other relevant factors as to whether the conduct is more serious. I would observe that, and I would agree with the state, that these are both the worst form of the offenses. And as far as tampering with evidence goes, I see a lot of tampering with evidence charges. Typically, that's somebody hiding, contraband or drugs or something like that on the floorboard, throwing it out the window. This is on the whole other scale. This is you secreting certainly a body as potential evidence against you. So this would be, on a scale of 1 to 10, this is the 10. This is the absolute worst form of a tampering with evidence charge that I have seen through my experience. As far as the abuse of a corpse, you don't see a lot of these type of cases, but they do exist where someone's taking pictures of dead bodies in the morgue or whatever it may be. This would be on the other end of that spectrum. Here, this is you disposing of Paige Johnson's body in a manner, I think it was described as disposing her like trash by the prosecutor. So that's exactly what we have here. As an abuse of a corpse, I think this would be the worst form of that offense as well. And certainly your efforts to tamper with that body and that evidence precluded certainly law enforcement from determining any type of cause or manner. So I think it's the worst form of the offenses. As I see your prior criminal history, Mr. Bumpus, I see an escalation in criminal conduct. You go from theft-related offenses where you went to prison on this to these type of offenses, which in my estimation are much, much more serious. So there's an escalation of criminal conduct. Recidivism factors under 2912D, that is his likelihood to reoffend. I would find that recidivism on whole is more likely. At the time that you committed the offense, you were under release from confinement. Specifically at the time of the instant offense, you were on post-release control and or parole through Kentucky authorities. So under their supervision, you committed these offenses, which makes recidivism more likely. You, as I alluded to, have a prior history of criminal convictions, and you've had other contacts with other courts that did not deter you from committing this offense. In other words, you've not been rehabilitated to a satisfactory degree prior to committing this offense, and you've not responded favorably to sanctions previously imposed for other criminal convictions. Last, but certainly not least, as far as the recidivism factors, the court finds that you show no genuine remorse for your conduct. The count 2 is a felony of the 5th degree. The court will certainly overcome presumption for community control or probation. This involves, again, I believe the worst form of the offense. And you committed this offense while you were serving or under previously sanctioned from a prison term on parole. And you've committed that offense while under sanction from parole, and you've previously served a prison term, which allows the court to overcome a presumption for prison on a felony of the 5th degree. Certainly the pain, suffering to the victim's family is unmeasurable. For many years, you've avoided the consequences of your actions. We've heard that said today, and I think that is certainly true. The courts considered the purposes of principles of sentencing, including the minimum sanctions necessary to accomplish the purposes of sentencing without imposing an unnecessary burden on state and local government resources. Just so the record's clear, I'm finding that the offenses both are more serious than conduct normally constituting the offense, and recidivism is more likely. I'm finding that prison is consistent with the purposes of principles of sentencing, that community control is not, and you're not amenable to available community control sanctions. Ms. Haywood, when she began her statement this morning, and had a quote from Dr. King. It's actually, he's quoting I can't offhand tell you who it is, but it's an older quote.
Jacob Bumpass showed no trace of humanity when he ended the life of a teenager. James Wasson, who previously cursed at a judge and kicked down a courtroom podium during an earlier appearance, had another outburst during a sentencing hearing in Butte. His recent outburst came after District Judge Ed McClain denied a plea bargain that would have reduced Wasson's sentence.
Court hereby sentences the defendant to 10 years MSP with 3 years suspended. And in relation to counts 2, 6, 7, and 11, the court also sentences the defendant to 10 years MSP with 3 years suspended on each count. Each of these counts shall run consecutive to each other. So the sentence in DC 17-267 is 50 years MSP.
No, I'm good.
Is 50 years with MSP, the 15th to be hereby suspended.
James, sit up. James, sit. Take him out of here, man.
In the matter of DC 277, the court hereby sentences the defendant on each 3 counts to 10 years MSP with no time suspended. So the defendant is hereby sentenced on 277 to 30 years MSP. The sentences DC 17-267 shall run concurrent to 277 and shall also run concurrent to the Judge Newman's sentence in 1788. You will have 120 days from today's date to review my written judgment, to make sure my written judgment complies with my oral judgment in this matter, and the clerk will hand you the necessary forms for sentence review.
And Your Honor, it would also run concurrent to DC 17-278, which was judgment plan.
Oh, and it shall run concurrent to that as well.
Any sentence prior to today runs it.
Right, and how much time will we give him credit for time served?
Your Honor, he has been incarcerated since the date of arrest, and we had that figured out the last time we were in front of the court. And we would add additional days as of from that last time. He was arrested on November 3rd, 2017. He would have credit from that date.
We shall give credit, shall we give it to him?
Thank you.
Do you have anything else before this one?
Would be standard conditions of probation.
And during that time period, the court would also enter the standard surcharges unless you this matter of standard conditions.
You can suck my head, James.
Anything further?
No, Your Honor, thank you.
James Wasson became irate when District Judge Kurt Kruger imposed a 35-year sentence at the Montana State Prison for several felony offenses. The man accused of killing his future mother-in-law remains in jail on a $1 million bond after his first court appearance, which lasted about a minute. His private attorney did not make any statements to reporters. The case is expected to go before a grand jury for an indictment. No one answered the door at the Plavkin home in Strongsville, and no members of the Plavkin family were present in court, where Jeffrey Scullin Jr. faced charges of murder, assault, tampering with evidence, and making a false alarm.
Bond is going to be set at $1 million cash surety or property.
It all unfolded the morning after the crime. Melinda Pleskovich's husband, daughter, and future son-in-law returned from dinner at the Strongsville Applebee's. They were led into the house by the family's special needs son, only to discover Melinda's body in the kitchen, stabbed and shot. It was Jeffrey Scullin who made the call to report the incident.
No, Pleskovich was attacked.
He was attacked by whom? Do you know?
No, we just came home. She's on the kitchen floor.
Police arrived at the scene, and several cars, including Scullin's pickup truck, were towed for inspection. Inside, officers found a large, bloody tactical knife on the rear bench. On Halloween, tests confirmed that the blood belonged to Melinda, and the DNA on the knife handle matched Jeff's. This discovery came just days after Scullin had served as a pallbearer at Melinda's funeral. However, questions remain, such as when exactly she died, whether her son may have witnessed the crime, and why the 20-year-old man, soon to be part of the family, allegedly tore it apart just days before his wedding. In addition to the blood evidence, the affidavit notes that investigators are also examining Scullin's cell phone and those of Melinda's family members for further clues. David Temple, a former high school football coach, has been twice convicted of killing his pregnant wife and Katie. However, he has been waiting for over 4 years for sentencing. Grace White reports that his fate is now in the hands of a new jury. Jury selection began to determine Temple's sentence. Since his wife's murder occurred in 1999, he faces a range of possible outcomes, from probation to life in prison. However, due to sentencing laws at the time, he could eventually be eligible for parole, as there was no life without parole option back then.
This day's about Belinda. This has nothing to do with David Temple.
That was Brian Lucas speaking after the second trial in 2019, which took place 10 years after his sister, Belinda Temple, was found in the closet of her Katy home. At the time of her murder, she was 8 months pregnant.
Guilty of murder as charged.
A jury twice convicted her husband, a football coach, of the murder. Prosecutors revealed that he was having an affair at the time of the killing and later married his mistress. However, she filed for divorce as the second murder trial began.
You see this on TV and you think, oh, this would never happen to you. Well, till you go through it, you don't know what it's like.
David Temple's first conviction was overturned due to prosecutorial misconduct. Although he was convicted again in a second trial, the jury could not agree on his sentence.
10 jurors in the retrial wanted life. For whatever reason, 2 jurors held out. And that brings us to where we are right now.
Andy Kahn, who has supported the family since the beginning, stated that they have faced numerous delays in the case, further exacerbated by the pandemic.
Interesting to see how the state presents a case in a sped-up fashion to a jury to get them up to speed, and they ultimately will determine the sentencing on David Temple.
David Temple's attorney has declined to comment ahead of the trial. Jury selection will continue tomorrow, and the sentencing phase will begin shortly after. The man convicted of beating and raping a 101-year-old woman in Milwaukee will be sentenced. DNA evidence was crucial in linking Antoine Perez to the crime. Due to the victim's advanced age, police worked quickly to solve this case, resolving it in under 5 months. Antoine Perez will face sentencing at the courthouse. During his initial appearance, Perez smiled and told reporters, "Now y'all going to make me a celebrity." Perez was charged with crimes that shocked even seasoned police officers. Prosecutors stated that he broke into the elderly woman's home in September intending to steal. When he found nothing, he beat and raped her. Perez was found guilty of burglary, aggravated battery, and sexual assault. At just 20 years old, he now faces up to 58 years in prison. On September 17, 2019, police discovered a partially consumed victim and a humanoid beast in a Rochester Hills apartment. The court has now decided the fate of Allison Weaver, who was sentenced for the cannibalistic attack in the woman's apartment. As the victim recounted the horrifying story in court, everyone was shocked, and the news quickly spread across the media. Let's hear what the victim had to say.
Okay. Good morning, Your Honor. Okay.
And I do have to hear this.
On September 16th, 2019, my life changed forever. I let Allison Thompson Weaver in my home, and in return, she tried to kill me. If the police hadn't shown up when they did, from neighbors calling 911, I wouldn't be here today. I have some memories of the attack that night, like bits and pieces of a horror movie. First of waking up in my own bed to find her in some animal-like crawling position, ready to pounce on me. Her strangling me, the expression on her face, until I was unconscious. The extreme pain I felt as I regained consciousness and could not move from being beaten and literally eaten alive from head to toe. I knew in my head what was happening to me, and I couldn't do a thing about it. And then she whispered the words, "You have to die." I begged her, "I'll do anything you want." But she laughed and replied, "It's too late," and began strangling me again a second time. This time I saw my loved ones flash before my eyes, and I saw a bright light, and I saw the end of my life. That's all I remember until the hospital. I do remember seeing pure evil in her eyes, though, and I truly believe nothing can save her. Every hour of every day I deal with excruciating pain because of what she did to me and the countless bite wounds, including my and I have permanent nerve damage all over my face and body. She bit off my ear and literally consumed parts of me, like my cheek, for instance. The pain in my neck, shoulder, and back, even with physical therapy, is only getting worse. I have been trying to avoid more surgeries if possible than I've already had. Talking about this does not fully express my emotions. The hundreds of pictures of what she did to me are absolutely horrendous and disgusting to look at. I am unrecognizable in those photos. And they just begin to show what this cannibalistic rapist put me through, all the while with a smile on her face. I'm learning to live with the pain and countless scars, as well as the countless stares I receive. But what is scaring me is the nonstop visions of her demon eyes killing me, and the fact that she will try to do this again someday. No one knows why she chose me to be her victim that night. The doctors at the hospital said it was nothing short of a miracle that I survived that attack that night. In closing, I don't think it's fair that she has taken so much away from me that I can never get back. She stole a part of me. She broke a part of me. She took away my sense of safety and trust, and so much more. Everything that this thing has done to me deserves more than 10 to 15 years behind bars. I will be living with these problems, pains, images, and fears for the rest of my life.
Thank you. Thank you. I can't address you by your name out of respect, but what you did was important, and I appreciate you standing behind it. And I appreciate you being here. It was critical, and hopefully you can. I hope your physical and emotional pain does ease somewhat. I know it's hard to say, but I do wish you the very best. Thank you again for helping me.
And I think there was a resolution that was worked out in this case to all the original charges that the defendant faced, to the maximum penalty that she can get on those charges. I've had obviously a number of conversations with the victim in this case about that resolution and ultimately getting to that resolution. I still believe that it is the best ultimate outcome for this case and for everyone involved. And I'm asking the court, having heard all that, ready for the PSI to still follow the kill agreement in this case, Your Honor.
Ms. Weaver, do you have anything to say today?
I would
address me.
I would like to apologize to the victim and to her family, and also to my family as well. I do feel really, really horrible about what happened. I wish I could take it away.
Do you have any idea why you did what you did that night? Were you under any other influence but, I think it's marijuana, but also alcohol?
I think other than some prescription medication.
Prescription medication. Have you ever done anything like this? The victim started off, her statement was, it was like being in a horror movie. And I wrote that down because when I reviewed the PSI, and I had to read it a few times because I couldn't believe what I was reading. And then when I talked to Mr. Cabot about it, first thing out of his mouth was, it was like reading a script for a horror movie. I can't even imagine what you were going through, I've never seen any pictures from it or any photographs, and I can't imagine what the scene looked like. And I've never ever understood anyone being violent toward another human being. But I've said it, which I've never said twice in the same way, but I've been up here for 25 years, and I've seen murder cases that were not nearly as violent as this case. And I can't imagine psychologically where you were in doing this to her, and the excuses that were made for it. And then this was the first time I saw the medical records in terms of all the wounds on her body and her face and her genitalia. Horrific is not even the word for it. I mean, what man suffers unto man, we've all heard that before, but this is an abomination. And the strength that you showed, ma'am, in showing up here today and making your statement is amazing, and I appreciate it. And you should know how strong you are, that you're able to come up here and say your piece. Many others could not have done that. And I hope you use that strength to go forward. And don't let her make you any less than what you are. And that is an incredibly strong human being who has amazing support. I've said this before. I've read all those letters. You have an amazing support system who only want the very best for you. And I do wish you everything to become as completely healthy as possible in every way. And thank you again for being here. I know you want more time than has been bargained by the prosecutor's office. But understand what was bargained for, the guidelines are lower than the group. In other words, they bargained for a higher sentence than I would have to give reasons to go higher than the guidelines. And that's not necessary here because there was an agreement for it. And I think this is the correct resolution to this particular matter. Because I don't think that these charges would ever have intended to reflect what actually happened here. These charges are not what was seen here. So in some ways, it's a gift what these charges are. It could have been worse. And I'm glad it wasn't worse for you physically. So I will follow the guidance we gave you in this matter. And I do set the court, having reviewed the probation department's report and recommendation following the killing, we just sentence you 10 years to 15 years in the Michigan Department of Corrections, 34 days jail credit. Count 2, counts 3, 4, and 5, 57 months to 10 years in the Michigan Department of Corrections, 34 days jail credit, $60 DNA cost, $100 by victim's fee, $270 state cost, criminal's fees to be determined, comply with DNA testing, HIV testing, sex offender registration requirements, no contact. I'll just say with the victim in this matter, the name will be on the report.
Thank you, Judge.
In any manner whatsoever. You have 42 days to reject certain appeals. You cannot afford an attorney. One will be appointed before an appeal by leave. This is a plea. Mr. Lynch, if you could please acknowledge Paul's rights for me. Mr. Lynch, if you could please acknowledge Paul's
I will, Judge. So acknowledge. May we approach this very briefly?
Certainly.
Sorry about that, Judge.
I guess now there's some rule where you're not supposed to say attorney fees to be determined, but it's not supposed to be. Okay, I just remember seeing an email, so I thought that was part of it.
Judge, I just realized when we went through the jail credit that on the face sheet of the PSI itself, not the sentence recommendation page, where it lists the final charges, it does say jail credit for 33 days. I think to comport with the Department of Corrections recommendation, that should be 34.
We'll make that change, Your Honor.
Thank you.
What page?
It's just the face sheet.
Second page.
Oh, okay.
In the case of Allison Weaver, the court sentenced her for the cannibalistic attack in Rochester Hills. She received a life sentence without the possibility of parole. In June 2019, in Milwaukee, Dante James caused the death of police officer Cowher due to careless driving. In court, everyone, including criminals, has the right to speak. However, the court focuses on the evidence, not the emotions of the offender, even if they express regret.
Mr. James, this is your opportunity to talk to the judge. Is there anything that you wish to tell the court before I impose a sentence?
Yes.
Go ahead.
Yes, Your Honor. Your Honor, and the family, thank you for allowing me to address the courts. I'm really not that good with words, so I took some time to write some things down from my heart. My name is Dante James. I'm 37 years old. I'm an alcoholic. I started drinking at the age of when my brother, who was then 24, told me that alcohol was better than the medication that I had been taking since I was 10 years old. I trusted him. Drinking made me feel like I had control of the voices in my head. The alcohol replaced my medication up to this point. I had not seen the truth. With the help of one of the guys that I'm currently locked up with, I'm understanding alcohol was not the truth. Alcohol was not the help for my mental health. Mr. Hurd lost his life because I was drinking and driving. I would like to take this time to say I am sorry to his family and friends. I know that losing someone you love is very painful. I have prayed and wished that this had not happened. I apologize to Mr. Hurd and his loved ones. I know my hurt is nowhere near their hurt these 2 years and 11 months. I want to truly apologize for my actions of leaving the scene of an accident. I also want the police officer Hurd's family, friends, and courts to know I am sorry. I'd just like to tell you how sorry that I am. I know his family and my family are here to see where my heart, mind, and soul is at in this letter. I have 5 DUIs and other charges since the day alcohol was given to me. Before alcohol, I had no adult run-ins with the law. My first DUI, I was given probation in Ohio, no programs. My second DUI, I was sent to prison, but did no programs because I was released. My third, I was in MSDF for 90 days and was not asked to complete the programs while I was there. My fourth, I got a year Hubert and 3 years papers. I did no programs. This one now is my fifth, and a bad thing happened. I do need help, and I mean help. You can see that, and I'm asking the courts today to please get me the help that I need. Sir, please take into consideration that I'm not trying to erase myself from leaving the scene of an accident. I was so wrong, and I want the police officer Hurd's mother, father, wife, and kids to know I am deeply sorry, and I mean sorry from the bottom of my heart. I am now taking my medication that I was taking at the age of 10 to 17. I know that alcohol was not the fix for my mental health problems. I would be going to prison for this crime. I would be getting mental health and AODA treatment. I would be taking these programs seriously. Again, I apologize to Mr. Hurd and his loved ones, my deepest sorrows. I send my apologies to my family and to my kids. Please forgive me. And Your Honor, that's it. Thank you for letting me speak.
Hearing about some court cases can be really upsetting. Sometimes, the things that come out in court are hard to accept as true.
Judge, this case comes from the early morning hours of June 18th, 2019. That was just switched over into Tuesday at 1:33 a.m. A man, a citizen of our city, his name was Officer Hur. He was an off-duty police officer, was going south on 60th Street and approaching Capitol Drive. The defendant, Dante James, was speeding west on Capitol towards the same intersection. The streets there are 35-mile-per-hour limits in both directions. Airbag analysis from after the crash shows that the defendant, 5 seconds prior to the crash in his Monte Carlo, was going 73 miles per hour, or a little over twice the legal limit. 3 seconds prior to the crash, the same information shows that he had his brakes on for 1 second, and 1 second prior to the crash, he had slowed to 62 miles an hour, or just under twice the legal speed limit. He wasn't wearing a seatbelt. Officer Hur, as he approached the same intersection and the same speed limit, was going 33 miles per hour, 5 seconds prior to the crash, and braked just 1 second prior, likely as he saw the defendant approaching from his left. Judge, I do have video queued up. There's a Citgo on the corner, a Citgo gas station on the corner of this intersection. which I have queued up. I'm going to play two channels for you, channel 5 and channel 9. This is channel 5, Judge. You'll see the victim's car approaching on the street going left to right. The defendant's car is going to speed this way west. This is the victim's light signal. It's green here a couple seconds prior to the crash. I'll tell you, if you watch it, you see it turns yellow just prior to his car entering the intersection. And all of that adds up to mean that the defendant had a steady red light both as he approached this intersection and at the time of the crash. So I'm going to begin playing this file. I'll play about 10 seconds of it.
Is there sound?
No.
Start and stop time, so state.
Judge, I believe I just started it at 9:33 and 44 seconds. I've now paused it. The timestamp's cut off because I'm slightly zoomed in so you can focus on the intersection. As you can see here, that's the victim's white car on the left. His lights just changed to yellow. As you can see, he's just maybe a car length and a half from the intersection. The defendant's car is still either not in view or just barely in view there on the left. I'm going to resume it from here. As you can see, Judge, the victim's car is basically wiped out in an instant by the defendant's. And if you watch carefully, I can play it again if you need me to, but the light for the victim does not change to red until after the accident occurs.
As to the impact, if I could see that again, Counsel.
Yes, Judge.
Had you noted where you stopped before?
I didn't, but I'll note it this time and I'll stop in the same spot. I've got it queued back up to 33 and 40 seconds. Play it again from here. I've stopped it there at 33:54, which I believe is the same time I stopped last time. I'm going to play one more angle, Judge. This will be camera 9. As I'm setting that up, I'll note that there's a bit of an illusion on these about the speeds. I noticed as I'm watching it, it looks like they're traveling at the same speed, but I think that's due to the perspective with the victim's car being in the foreground. As I said, we know from the crash analysis that the defendant's car is going about twice the speed of the victim's car as he approaches the intersection. I will. This is a second view, Judge. This is facing east, so the victim's car is going to cross in front of you in the foreground. The defendant's car is going to be speeding up from east, going westbound on Capitol here. I'm going to start it at 33:36, or about 10 seconds before the crash. That's the defendant's car approaching. I've stopped it at 33:54. Judge, the other physical thing I was hoping that you'd look at today are just a couple pictures of the scene afterwards. Got 3 of them. There's a little bit of glare on this photograph. That's the defendant's Monte Carlo that's flipped in the opposite direction on the right there. You're facing westbound on Capitol, and that's the victim's car on the left on the other right pole. I'll give these to the courts afterwards.
Sure, you'll mark these as exhibits.
I will, Judge. Here's a close-up of the defendant's front end, showing, giving you an idea of the impact speed. And finally, Judge, here's the side view, which is the struck portion of the victim's car. What the defendant hit as he sped through that red light. Judge, on the date this happened, the defendant was revoked. His license was revoked due to April 19th, 2018 conviction for OWI as a fourth offense. The revocation was still active about a year later when our crash happens. He also had an ignition interlock device requirement, which meant that his legal allowed alcohol level was a 0.02. There was another driver who was a witness to this. He saw that he mentioned that he had seen that Monte Carlo a few minutes prior going east on Capitol, that it made a wide U-turn, and the witness actually had to change lanes to avoid it.
There was something in the defendant's statement from February 23rd, 2022 that struck me. The defendant's talking about the drinking made me feel like I had control of the voices in my head. The alcohol replaced my medication. Up to this point, I had not seen the truth. And the truth is, Mr. James, you're dangerous, violent, and reckless. You caused the death of an innocent human being in our community under aggravated circumstances. Prior attempts by the justice system to help you to correct your problems failed. And ultimately, the personal responsibility falls on you. This sentence will reflect the 3 sentencing factors, and I want everyone to understand that I have a lot to say after I say the number of years in the sentence. So I do need order in the courtroom. Also, Wisconsin's had bifurcated sentences for 20-some years. So I follow the law and indicate what the entire sentence is and then bifurcate it. So I want to make sure that this court sentence is understood. So we had some discussions about consecutive time. And this court's view is very clear and different than Attorney Kovac's. Consecutive sentences are very appropriate when the conduct and the charge reflect different criminal acting and thinking. In other words, when the defendant's speeding down, it was Capitol Drive State?
Yes.
He's reckless, he's endangering the safety of other people, and he's doing it with utter disregard for human life because he's about to take a human life. That's separate from the moment that he had the collision and the subsequent. So that conduct, while connected to the incident, is entirely separate because there are homicide by intoxicated users where there aren't other counts for first-degree reckless endangering safety involving conduct of a different set of circumstances. Likewise, when you look at both of these counts, they're very different in criminal thinking and acting than the OWI fourth that he was serving. So the 2017 facts for the OWI fourth reflect a certain level of criminal thinking and acting, and the 2 counts here reflect a different level of criminal thinking and acting, and each one draws a response from this court, and he's to be held accountable for each one. And that's important because he needs this long term of imprisonment to change. And if I were dealing with someone who'd been in the court system 4 times, and whatever the court system's response was, change failed, I would know right away that I needed a lengthy term of imprisonment to enforce that change. Because ultimately, every sentence is about change. But I listed the objectives at the beginning. They were punishment of the defendant, protection of the community, deterrence of others, and to some degree, rehabilitation. So the defendant knows, and so there's no question, this sentence I pronounced today will be consecutive to any other sentence or any other reconfinement. But I simply say consecutive to any other sentence. Secondly, counts 1 and 5 are consecutive to each other. He's earned this separate punishment for these 2 counts, and I reject the defense argument to make them concurrent. Count 1 is a Class C felony, up to 40 years in prison, and it's broken down into up to 25 years potential initial confinement and up to 15 years potential extended supervision. I said this is an aggravated case with a high need to protect the public, and generally his rehabilitative needs are severe and he needs to be incarcerated, but there were some aspects. So I reject the maximum sentence. However, this sentence does reflect a greater than usual amount of prison time. Count 1, his sentence is 30 years in the Wisconsin State Prison, broken down into 20 years of initial confinement and 10 years extended supervision. Count 5 is consecutive. Count 5 is 8 years in the Wisconsin State Prison, broken down into 5 years of initial confinement and 3 years extended supervision. So again, his total sentence is 38 years. His total consecutive initial confinement is 25 years, and his total extended supervision is 13 years. And because they're consecutive sentences, he'll receive credit for whatever independent credit he has. But defense is unable to advise the court of that, and I'm willing to do that at a restitution hearing or the like.
In West Virginia, a jury has found Benjamin Taylor guilty of raping and murdering his girlfriend's baby, Emma Behringer. After hearing testimony, the jury took only 2 hours to convict 34-year-old Taylor on all charges. Emily was assaulted and killed on October 2, 2016, at a home in Fairplain, Jackson County. Throughout the trial, experts, investigators, friends, and family testified. Taylor remained mostly emotionless, staring straight ahead and avoiding looking at the evidence on a large courtroom screen. He didn't react, even when disturbing photos of Emma's bruised body were presented. However, after the verdict was read, Taylor broke down in tears.
A verdict of the jury: you have been found guilty of the offense of murder in the first degree. It's contained in count 2 of the indictment. Guilty of a child abuse as contained in count 3 of the indictment, and sexual abuse by a guardian. Whether that verdict was then.
Family members say they finally feel that justice has been served for Emily. The sentencing for Benjamin Taylor will take place at a later date. Later, he was sentenced to life in prison without the possibility of parole. The case revolves around Matho Moore. On May 25, 2020, in Westerville, Moore's wife, Emily Noble, disappeared. A few months later, her body was discovered. Just over a year after her disappearance, Moore was arrested for her murder. After considering every aspect of the case and investigation, the jury decided. The judge would soon deliver the verdict.
The court will now announce the verdicts. Verdict on count 1. We, the jury, being duly impaneled and sworn, find the defendant Matthew L. Moore not guilty of as he stands charged in count 1 of the indictment, dated the 26th of August, 2022, signed by all 12 members of the panel. Verdict on count 2. We, the jury, being duly impaneled and sworn, find the defendant Matthew L. Moore not guilty of as he stands charged in count 2 of the indictment, dated 26 August 2022, and signed in ink by all 12 members of the panel. Verdict on count 3. We, the jury, being duly impaneled and sworn, find the defendant Matthew Moore not guilty of felonious assault as he stands charged in count 3 of the indictment, dated August 26, 2022, signed by all 12 members of the panel. Ladies and gentlemen, I cannot personally enough express my appreciation for the time and the attention you have given to this court during the course of this trial. This is one of the longer trials that occur, and you all were willing to give your time and absolute attention to this matter, and you certainly received the thanks not only of this court but the community as well for your service. As I said earlier, and I believe it again, your participation has strengthened and fully served our institution of justice in this county and everywhere else, for that matter. So we have now concluded your service to the court in this matter. I will, I guess number one, I'm going to share with you, you are released from your admonition. So now you may speak to anyone that you wish about this matter. You may review anything that's been going on. It's entirely your prerogative. I will now discharge you, and you can go back to the jury room. I will tell you that I would like to go back and speak to you privately if you're willing to do that. In other words, if you wish to leave, you're certainly entitled to do that. If you'd like to go back when I concluded my business here, I'll briefly go back and speak to you, share some moments with you, and then certainly you can go on your way. So it's up to you, but I'll have you go back to your jury room now, and we'll proceed with a few things in here, and I'll be back there shortly. Thank you. Mr. Moore, I think from day one, everyone's wanted justice for your wife, Emily. And I've heard that phrase a lot, and I think everyone truly desires that. But I think the jury has also said justice for Emily is not injustice for you, and they have reaffirmed that. I will just formally say I am terminating the bond previously set in this case, and you will be discharged, and you are free to go. We will do that. We have an entry that we'll prepare immediately to cause that to happen. All right. Anything else from the state? No, Your Honor. Thank you. Anything else from counsel? No, Your Honor. I'm going to ask them if they would be willing to speak to counsel. That's really one of the main things I'm going to be doing. So if any of you would like to do that, I will come back out here and let them know, and then you can go speak to them if you wish. Thank you for your service in this case. You did a fine job, and same with you folks. So we are in recess. We will file the verdicts with the clerk. We'll proceed from there. Thank you.
Recco Johnson has been sentenced to 35 years in prison after a jury found him guilty of sexually battering his ex-girlfriend's daughter while the mother was at work.
The defendant is guilty of lewd and lascivious molestation as charged. The defendant is guilty of sexual battery.
Recco Johnson left a Tampa courtroom a convicted sexual predator. A jury found him guilty of raping a minor. Now 3 months later, he would be handed his punishment. The victim wanted the max of 75 years. The prosecutor pushed for it.
The allegations that have been proven in this case are egregious.
The victim's mother was heard too. Johnson, who was acting as his own attorney during the trial, was accused of raping his ex-girlfriend's 15-year-old daughter while her mother was at work back in April of 2019. The girl told the jury all about it, but what made it nearly unbearable was having to answer questions from the man who's accused of raping her.
You said I came in your room and you had your phone in your hand. Do you have any opportunity at any time to call the police?
No, I was too busy telling you to stop and pushing your hands off of me.
Later, Johnson told the jury the young girl came on to him.
The real victim, should be found not guilty.
But the jury didn't buy it. Now a Tampa judge had the final say.
The victim in this case was a 15-year-old little girl. That was supposed to be simple for a 15-year-old. Spend time with their friends, think about what they're doing in the future. That all came crashing down because of you and what you did.
Now Johnson will spend the next 35 years in prison because of what he did.
And once he is released from prison, Johnson will also have to serve 10 years of offender probation.
Isaiah Hemphill has been sentenced for his involvement in the 2017 shooting that led to the death of Justin Penland.
Mr. Welty contacted Justin Penland, set up a deal to buy marijuana from him. All four co-defendants knew that once they did contact Mr. Penland, that they would be robbing him. Jonte Williams was the driver of the car. He blocked Mr. Penland in. At that point in time, Mr. Hemphill took a gun from Jonte Williams, got out of the car, shot Justin Penland in the head one time. He died almost immediately on the scene.
Day in question, he was under the influence of a mixture of drugs, marijuana, crack, ecstasy, and liquor, which are not offered as an excuse, but would explain his impulsive and rash action on that day.
Attempted armed robbery. The sentence of the court is to be committed to state farm correctional period of 20 years. Sentence is run concurrent, credit for 216 days. Voluntary manslaughter. The sentence of the court is to be committed to the state farm correctional period of 20 years. Sentence run concurrent and credit for 216 days. Possession of a weapon during the commission of a violent crime. The sentence of the court is to be committed to the state Department of Correction for a period of 5 years. The sentence is to run concurrent. Credit for 216 days. Good luck to you. Thank you.
But the state is asking for 10 years based on the fact that they did cooperate. And without the three of them cooperating, Isaiah Hemphill probably would never have been arrested and would never have been held accountable for his actions, which ultimately
Very likely would not have been convicted.
Would not have been convicted, would not have been arrested. But for the three of them providing his name and the details of that, I don't know that the state would have ever been able to ascertain who actually pulled the trigger, because there was nothing linking him to the crime scene. There's no other forensics, there's no fingerprint, there's no DNA. Other than their statements, there would be nothing tying him to the crime scene.
Are you indeed guilty of attempted armed robbery?
Yes, Your Honor.
Guilty of obstruction of justice?
Yes, Your Honor.
Guilty of possession with intent to distribute marijuana?
Yes, Your Honor.
Guilty of unlawful carrying of a pistol?
Yes, Your Honor.
Guilty of possession of a handgun by a person under the age of 18?
Yes, Your Honor.
Mr. Welty, those facts have been related to the court of truth?
Yes, Your Honor, most guilty.
Are you indeed guilty of obstruction of justice?
Yes, Your Honor.
Guilty of attempted armed robbery?
Yes, Your Honor.
And are you guilty of possession of intent to distribute marijuana first offense?
Yes, Your Honor.
October 26, 2017 is a day that will forever haunt me and my family. I will never forget the feeling of my heart leaving my chest when I saw the man that I love and the father of my children laying in a hospital bed, lifeless. This past Sunday was Father's Day, and instead of his daughters making him cards and breakfast in bed and celebrating what a great father they had, they sent balloons to heaven with tears in their eyes.
It appalls me that a 27-year-old man would approach a 17-year-old kid on the street and ask him if he wanted to buy drugs. That led up to all the other things that we've heard about here today. For one bad decision after another by many people, including Mr. Penland, and my heart breaks for you. It really does. I'm so sorry.
I just want to say that I'm more than sorry for Justin and his family. I pray for Justin's family every single day and night for them to keep strength and for our dear Lord to watch over them. I shed tears almost every night for Justin and his family.
I'd like to say that I'm honestly sorry that what happened. I didn't know what happened was going to happen. That's all.
Isaiah Hemphill received a 20-year prison sentence. Shawn Allen Welt, who is 18, was sentenced to 10 years, while Donovan Kendrick Allen, also 18, will serve 9 years. In a chilling case that rattled the tight-knit community of Wadsworth, Ohio, teenager Gavin Ramsey was convicted on multiple charges related to the death of 98-year-old Margaret Douglas. The tragic incident occurred in April, when Douglas, a widow living alone on Portage Street, was found strangled in her home. She had been hidden in a closet, a grim detail that highlighted the brutality of the crime. The investigation uncovered damning evidence tying Ramsey to the murder. Authorities discovered Douglas's wallet in Ramsey's home, and, most disturbingly, photos of Douglas stored on his phone. These findings, combined with a confession Ramsey made after being detained in Cleveland a week later, revealed a chilling level of premeditation. Initially, after being indicted by a grand jury, Ramsey pleaded not guilty. However, he later changed his plea to no contest on all charges. This allowed Medina County prosecutors to present their evidence to the judge, who found Ramsey guilty. During sentencing, Judge Joyce Kimbler addressed Ramsey directly, ensuring he fully understood the severity of the proceedings before announcing his sentence.
It is my understanding that today you wish to withdraw your previously entered pleas of not guilty and enter pleas of no contest to the indictment. Is that correct?
Yes, Your Honor.
Okay, in order to do that, we need to have a dialogue to confirm that you are making a knowing, intelligent, and voluntary decision to change your plea with an understanding of the constitutional rights that you may be waiving in this matter, okay?
Yes, Your Honor.
Are you indeed the Gavin M. Ramsey who is named in the indictment in case number 18 CR 0548?
Yes, Your Honor.
As you stand here before me today, are you under the influence of any drugs or alcohol?
No, Your Honor.
Are you a United States citizen?
Yes, ma'am.
Do you read and understand English language?
Yes, ma'am.
What is your date of birth?
3/23/01.
How far did you go in school?
Senior year.
Are you presently on felony parole or felony probation?
No, ma'am.
To your knowledge, do you suffer from any mental illness?
Not to my knowledge.
Have you ever been deemed by any court to be incompetent?
No.
Have you had ample opportunity to discuss the facts of this matter as well as the potential penalties with attorney's defense?
Yes, ma'am.
Are you satisfied with the quality of the legal representation you receive from attorney's defense in this matter?
Yes, Your Honor.
Then it is my understanding you're going to withdraw your previously entered pleas of not guilty and enter pleas of no contest to the indictment, which states at count 1 that on or about the 6th day of April 2018 in Medina County, Ohio, you unlawfully did purposely and with prior calculation and design cause the death of Margaret M. Douglas in violation of section 2903.01A of the revised code, contrary to the statute in such cases made and provided and against the peace and dignity of the state of Ohio. Do you understand the nature of the charge set forth against you in count 1?
Yes, Your Honor.
What do you think it says you did wrong?
That I caused the death of Margaret Douglas.
Do you understand? Count 2 states that on or about the 6th day of April 2018 in Medina County, Ohio, you purposely did cause the death of Margaret M. Douglas while committing or attempting to commit aggravated burglary in violation of section 2903.01B of the revised code, contrary to the statute in such cases made and provided and against the peace and dignity of the state of Ohio. Do you understand count 2?
Yes, Your Honor.
What do you think it says you did wrong?
That I caused the death of Margaret Douglas.
Count 3 of the indictment states that on or about the 6th day of April 2018 in Medina County, Ohio, you purposely did cause the death of Margaret M. Douglas while committing or attempting to commit kidnapping in violation of section 2903.01B of the revised code, contrary to the statute in such cases made and provided and against the peace and dignity of the state of Ohio. Do you understand count 3?
Yes, Your Honor.
What do you think it says you did wrong?
That I caused the death of Margaret Douglas.
Count 4 of the indictment states that on or about the 6th day of April 2018 in Medina County, Ohio, you purposely did cause the death of Margaret M. Douglas while committing or attempting to commit a trespass in a habitation when a person is present or likely to be present in violation of section 2903.01B of the revised code, contrary to the statute in such cases made and provided and against the peace and dignity of the state of Ohio. Do you understand the nature of the charge set forth in count 4?
Yes, Your Honor.
What do you think it says you did wrong?
That I caused the death of Margaret Douglas.
Count 5 of the indictment states that on or about the 6th day of April 2018 in Medina County, Ohio, you unlawfully did purposely cause the death of Margaret M. Douglas in violation of section 2903.02A of the revised code, contrary to the statute in such cases made and provided and against the peace and dignity of the state of Ohio. Do you understand the nature of the charge set forth in count 5?
Yes, Your Honor.
What do you think it says you did wrong?
That I caused the death of Margaret Douglas.
Count 6 of the indictment states that on or about the 6th day of April 2018 in Medina County, Ohio, you unlawfully did cause the death of Margaret M. Douglas as a proximate result of you committing or attempting to commit an offense of violence that is a felony of the 1st or 2nd degree to wit, aggravated burglary, in violation of section 2903.02b of the revised code. Do you understand the nature of the charge set forth against you in count 6 of the indictment?
Yes, Your Honor.
What do you believe it says you did wrong?
That I caused the death of Michael Douglas.
Count 7 of the indictment states that on or about the 6th day of April 2018 in Medina County, Ohio, you unlawfully and knowingly did, by force, stealth, or deception, trespassing 359 40th Street, Wadsworth, Ohio, an occupied structure, or a separately secured or separately occupied portion of an occupied structure, when another person other than your accomplice is present, with purpose to commit therein a criminal offense, and you inflicted or attempted or threatened to inflict physical harm on Margaret Douglas, this being a felony of the first degree. Do you understand the nature of the charge set forth against you in count 7 of the indictment?
Yes, ma'am.
What do you think it says you did wrong?
That I entered Margaret Douglas's house while she was present.
Count 8 of the indictment states that on or about the 6th day of April 2018 in Medina County, Ohio, you did by force, threat, or deception, knowingly under circumstances creating a substantial risk of serious physical harm to Margaret M. Douglas, did restrain Margaret M. Douglas of her liberty, and did not release her to a safe place unharmed, in violation of section 2905.01b2 of the revised code, a felony of the first degree. Do you understand the nature of the charge set forth against you in count 8 of the indictment?
Yes, ma'am.
What do you think it says you did wrong?
That I restrained Margaret Douglas.
Okay. Count 9 of the indictment states that on or about the 6th day of April 2018 in Medina County, Ohio, you unlawfully did treat a human corpse in a way that would outrage reasonable community sensibilities, in violation of section 2927.01b of the revised code, a felony of the 5th degree. Do you understand the nature of the charge set forth against you in count 9 of the indictment?
Yes, Your Honor.
What do you think it says you did wrong?
That I handled the corpse of Margaret Douglas.
Do you understand that a plea of no contest, while not an admission of your guilt, is an acknowledgement of the truthfulness and accuracy of all of the allegations contained in the indictment?
Yes, Your Honor.
Do you understand that upon pleading no contest, the court can immediately proceed to find you guilty?
Yes, Your
And
Honor.
upon finding you guilty, the court could immediately choose to impose sentence.
Yes, Your Honor.
Do you understand the court is not bound by any sentencing agreement which may be reached between the state of Ohio and attorneys advancing on your behalf?
Yes, Your Honor.
Do you understand that count 1, that being aggravated murder, carries with it a potential penalty of 20 years to life, 25 years to life, 30 years to life, or life without the eligibility of parole in prison?
Yes, Your Honor.
Do you understand that it carries with it a potential fine of $25,000 and that a prison term is presumed mandatory?
Yes, Your Honor.
Do you understand that count 2 carries with it a possible prison term of 20 years to life, 25 years to life, 30 years to life, or life without the eligibility of parole in prison, and a prison term is mandatory?
Yes, Your Honor.
Do you understand it also carries with it a possible fine of $25,000?
Yes, ma'am.
Do you understand that count 3 carries with it a possible prison term of 20 years to life, 25 years to life, 30 years to life, or life without the eligibility of parole, and a prison term is mandatory in count 3?
Yes, ma'am.
Do you understand it also carries with it a possible fine of $25,000?
Yes, ma'am.
Do you understand that count 4, again, carries with it a possible prison term of 20 years to life, 25 years to life, 30 years to life, or life without the eligibility of parole, and that a prison term is mandatory?
Yes, ma'am.
Do you understand it also carries with it a possible fine of $25,000?
Yes, ma'am.
Do you understand that count 5 carries with it a prison term of 15 years to life, a prison term is mandatory, and it carries with it a maximum fine of $15,000?
Yes, ma'am.
Do you understand that count 6 also carries with it a prison term of 15 years to life, which is mandatory prison term, and also a potential fine of $15,000?
Yes, ma'am.
Do you understand that count 7 carries with it a possible prison term of 3 to 11 years in prison? A prison term is not mandatory, but it is presumed necessary, and it carries with it a possible fine of up to $20,000.
Yes, ma'am.
Do you understand that count 8 also carries with it a prison term of 3 to 11 years in prison? A prison term is not mandatory, but it is presumed necessary, and also carries with it a possible fine of $20,000.
Yes, Your Honor.
Do you understand that count 9 carries with it a possible prison term of 6 to 12 months in prison and a possible fine of $2,500?
Yes, ma'am.
Do you understand that theoretically these terms could be run consecutively, one after another, not necessarily all concurrently, all at the same time?
The judge explains to Ramsey the challenges and consequences he will encounter once he is out of prison.
Yes, Your Honor.
Do you understand that after you've been to prison, if you were released from prison, count Count 7 and Count 8 carry with it potential periods of post-release control, mandatory post-release control of 5 years.
Yes, Your Honor.
Do you understand that Count 9 carries with it a possible period of post-release control of 3 years?
Yes, ma'am.
Do you understand that when these mandatory periods of post-release control would be imposed, when they were imposed, if you were released from prison, if you violated the terms of that supervision, the adult parole authority is authorized to return you to prison for up to 9 months for any single violation, up to a maximum of 50% of your prison term for all violations.
Yes, ma'am.
Do you understand that some of these provisions do not apply to the counts of aggravated murder and murder?
Yes, ma'am.
Other than what we have discussed here today, has anybody made any promises or threats to induce you to change your plea?
No, ma'am.
Do you understand that by entering a plea of no contest, you will be waiving important constitutional rights, including the right to a trial by jury of 12 persons, which would require a unanimous verdict, the right to have your attorney cross-examine witnesses who would appear to testify against you, your right to have subpoenas issued to have witnesses brought to court to testify on your behalf, your right not to testify against yourself, your right not to have your silence used against you to prove your guilt, and your right to require the state of Ohio to prove the charges against you beyond a reasonable doubt.
Yes, Your Honor.
And with this knowledge, what plea do you enter today to count 1 of the indictment, aggravated murder in violation of RC 2903.01A?
No contest.
And what plea do you enter today to count 2 of the indictment, aggravated murder in violation of RC 2903.01B?
No contest.
And what plea do you enter to count 3 of the indictment, murder in violation of, count 3 of the indictment, also aggravated murder in violation of RC 2903.01B?
No contest.
And what plea do you enter to count 4 of the indictment for aggravated murder in violation of RC 2903.01B?
No contest.
And what plea do you enter today to count 5 of the indictment for murder in violation of RC 2903.02A?
No contest.
And what plea do you enter to count 6 of the indictment, murder in violation of 2903.02B?
No contest.
And what plea do you enter today to count 7 of the indictment, aggravated burglary in violation of RC 2911.11A1, a felony of the first degree?
No contest.
And what plea do you enter today to count 8, kidnapping in violation of RC 2905.01B2, a felony of the first degree?
No contest.
And what plea do you enter today to count 9, abuse of a corpse in violation of RC 2927.01B, a felony of the 5th degree?
No contest, Your Honor.
I do have here before me your written plea of no contest. Is there anything else that you would like to say as it relates to the change of plea, Attorney Stephenson?
No, Your Honor, we would waive a presentation of facts for the hearing.
Anything else you would like to say as it relates to the change of plea, Prosecutor Thompson?
No, Your Honor.
Then let the record reflect the defendant is making a knowing, intelligent, and voluntary decision to withdraw his previously entered pleas of not guilty and his tender pleas of no contest to 1 count of aggravated murder in violation of RC 2903.01A, 3 counts of aggravated murder in violation of RC 2903.01B, 1 count of murder in violation of RC 2903.02A, and 1 count of murder in violation of RC 2903.02B, 1 count of aggravated burglary in violation of RC 2911.11A1, a felony of the first degree, 1 count of kidnapping in violation of RC 2905.01B2, a felony of the first degree, and 1 count of gross abuse of a corpse in violation of RC 2927.01B, a felony of the 5th degree. Court finds the defendant has been informed of all of his constitutional rights, that he understands the nature of the charges, the effect of a plea of no contest, as well as the possible penalties which could be imposed. Therefore, the court accepts the defendant's plea of no contest and finds him guilty of 1 count of aggravated murder, finds him in violation of RC 2903.01A, finds him guilty of 3 counts of aggravated murder in violation of 2903.01B, finds him guilty of 1 count of murder in violation of RC 2903.02A, finds him guilty of 1 count of murder in violation of 2903.02B, finds him guilty of 1 count of aggravated burglary in violation of 2911.11A1, a felony of the first degree, finds him guilty of kidnapping in violation of 2905.01B2, a felony of the first degree, and finds him guilty of gross abuse of a corpse in violation of 2927.01B, a felony of the 5th degree. I will order a pre-sentence investigation. I will schedule this for a mitigation hearing on January 3rd, 2019 at 1:30. I am also going to order that certain reports be provided on behalf of the defense. Do you have any motions?
After announcing the sentence, the judge turns to the defense attorney, asking if she has anything to add. In response, she requests that a mental health evaluation be conducted.
Your Honor, at this time I would ask the court to order a mental health evaluation. It is provided for in terms of being able to be ordered pursuant to Revised Code Section 2929.03 prior to sentence in this matter. So I would ask that he be referred to the Summit Diagnostic Center in order for that mental health evaluation to be completed.
The court will grant that motion and order that the evaluation be completed by December the 7th, 2018. A copy should be provided to the court, who will then provide a copy to both counsel.
Thank you, Your Honor.
Any other motions on behalf of the defendant?
No, Your Honor.
Any reports that the defendant expects to introduce at the mitigation hearing other than that particular report by the psychodiagnostic clinic should be provided to the state of Ohio no later than November 16, 2018. Any sentencing briefs to be filed by either the state of Ohio or the defense should be filed by December 27, 2018 in preparation for the mitigation hearing.
The judge then turns to the prosecution, asking if they have anything further to contribute.
Thank you. At this time, Your Honor, two motions. One, we request that the defendant be transferred immediately from the juvenile detention facility to be held in the county jail pending finalization and sentencing. And the second, we ask that the court lift the previously imposed gag order.
Ramsey, clearly overcome with emotion during the hearing, tried to hold back tears as the judge directed that he be transferred to the Medina County Jail to await his sentencing.
On behalf of the defendant, do you have any objection to the defendant being transferred to the Medina County Jail at this time?
I do, Your Honor. The revised code says that the detention center is a particular establishment for housing juveniles accused of crime, and that juveniles accused of that crime can be held at the juvenile detention center until such time as they are actually sentenced or disposed of. Because he has not yet been sentenced and will not be sentenced until January 3rd, I would ask the court to allow him to remain in the custody of the juvenile detention center. He's had no problems while being at the detention center. I spoke this morning to the assistant superintendent. They've had no objections with his behavior there, and there's no issue with him continuing to stay there. I would ask that the court allow him to remain there.
I believe that is up to the discretion of the court. The defendant has now been convicted of these matters. He is no longer accused, so the court will order they be transferred to the Medina County Jail. Any objection to the lifting of the gag order?
Your Honor, because we have a sentencing hearing and mitigation scheduled for January 3rd, I would ask that the gag order be continued until the case is ultimately disposed of.
Prosecutor Thompson?
Your Honor, the sole purpose that the defense established the gag order under and requested was to protect the potential jury pool. That issue is now behind us. There is no constitutional basis prohibiting the distribution of the information in this matter. Therefore, the gag order has run its usefulness, and we would ask that it be lifted.
The court will lift the gag order at this time, as there is no potential for prejudice to the jury pool in this matter. Anything else at this time on behalf of the state of Ohio?
Nothing further, Your Honor.
Anything else on behalf of the defendant?
No, Your Honor. Thank you.
Thank you. We are adjourned.
In January 2019, Medina County Common Pleas Judge Joyce Kimbler sentenced Ramsey to life in prison without the possibility of parole, emphasizing the deliberate and premeditated nature of his actions. Ramsey later filed an appeal, claiming that his age and potential for rehabilitation were not given adequate consideration. However, the 9th District Court of Appeals upheld the original sentence. Margaret Douglas was fondly remembered as a warm-hearted, independent woman who had lived a rich and meaningful life. Her tragic loss deeply affected her family and the Wadsworth community, leaving them in intense grief. The sentencing was a crucial moment in the case, solidifying Ramsey's fate of spending the rest of his life behind bars without any chance of parole. It has been 4 years since the horrific death of James Dunkley Cruz, and as more details emerged, additional individuals were charged in connection with the Albuquerque boy's death. In court, prosecutors detailed the injuries found on James during his autopsy. One of the individuals charged in his death received a sentence for her role in this tragic crime.
It's almost been 4 years since the death of James. He's almost been dead longer than he was alive.
Pamela Esparza, the third suspect charged in the brutal death of James Dunkley Cruz, returned to court for sentencing. James died in 2019 after prosecutors allege he endured extensive abuse at the hands of his mother, Krista Cruz, and her associates, including Esparza and Zarek Marquez. Marquez has already been sentenced to life in prison for his role in James's death.
I know that Mrs. Esparza isn't the one that killed James. But when you still harm a child and hit them and hurt them and let them be abused in front of you, your inaction is action.
The state requested the maximum sentence of 18 years under Esparza's plea deal. Prosecutors argued that Esparza lied to the Children, Youth, and Families Department and family members about James living with them and was aware of the abuse while concealing it from everyone. In response, Esparza's lawyer stated that she was in an abusive relationship with Marquez at the time.
I'm asking the court to please take mercy on Ms. Esparza.
Esparza's lawyer also blamed the Children, Youth, and Families Department for failing to protect James and allowing the situation to occur.
One thing we could all agree about here is that the system completely and utterly failed James Dunkley.
Then Esparza herself spoke, expressing her feelings about the situation.
I want to be accountable to my own role as a protector and guardian of James. I want you all to understand that I never meant for this to happen. But it did. I know the passing of James has a ripple effect in my community and in the broader community we live in, due to the loss of a precious life.
However, Judge Stan Whitaker questioned where her tears were for James, stating that she had the power to save him but chose to do nothing.
I don't know that in my years of sitting on the bench hearing this kind of carnage, her case, that's worse.
He sentenced her to 13 years in prison, followed by 5 years of probation, stating that anything less would be a slap in the face to James.
My hope from this is that at least the message to CYFD, and I'm sure they get it a lot, is that things just really have to be different. That maybe more lives of children can be saved with a little bit more robust involvement.
Esparza will turn herself in to begin her sentence. Meanwhile, James's mother, Krista Cruz, is also scheduled to be sentenced. She also accepted a plea deal and was imprisoned for up to 22 years. The inmate who escaped from the Broward courthouse a week and a half ago returned to the same courtroom for a hearing, appearing all smiles. Deonte Rezeles, who faces charges of escape and first-degree murder, was back under heavy security. Upgrades have already been made at the courthouse, with more changes planned. Chained from hand to foot, Rezeles returned to the same Broward courtroom he had escaped 11 days earlier. As he was led down the hallway in his jail uniform and cuffs, he mouthed a message to his family, which did not sit well with the deputies. Rezeles' brother was eventually escorted out of the hearing. The hearing focused on whether Rezeles required a mental health evaluation, which was prompted by a comment he had made.
I'm not saying I feel mentally disturbed, but not saying that I won't.
Rezeles' family defended his decision to escape, claiming that he was wrongly accused of killing Jill Sue in her home back in 2014.
I think he's innocent, and I believe he deserves a fair trial. They just want a closed case, so they pinned that on him. I believe he was framed.
Are you Winston George Jr. Russell?
Yeah.
The man accused of driving the getaway car during Rezeles' escape never appeared in court.
He refused to come up. We are asking for some doctors to be appointed to determine whether or not he is competent to proceed at this point.
Since Rezeles' escape, the courthouse has seen an increase in armed deputies. Sources revealed that a man carrying a knife managed to get past security, but was quickly apprehended shortly after. The sheriff stated he was unaware of the breach, but is focused on ensuring armed deputies are present during criminal court and domestic violence cases to enhance security.
My job as the sheriff of Broward County is to save lives. I wasn't elected to save dollars.
I'm fiscally responsible.
Securing funding for more armed deputies in the courthouse will be a key topic in upcoming budget discussions with county commissioners. Rezel's escape is expected to play a major role in these talks, highlighting the need for increased courthouse security. Later, he was sentenced to life in prison for the murder of Jill Halliburton Sue and 15 years for escaping from the Broward courthouse. A Bowie County jury has sentenced Taylor Parker to death for the capital murder of 21-year-old Reagan Simmons Hancock and her unborn baby, Brax Lynn Sage.
A heavy burden feels lifted. I feel like now we can start trying to heal. We don't have this over our heads. We know where she's going to be, we know where she's at, and she's taken care of.
Then this afternoon, the courtroom was packed with members of Reagan's family, and many of them broke down in tears as the verdict was read. Now, this comes after 2 months of testimony with mountains of evidence and more than 140 witnesses taking the stand. In closing arguments, prosecutors emphasized the heinousness of the crime and reminded the jury that they could send Parker to death row based on that alone. But on top of that, they argued that they clearly showed that Parker poses a future danger. Parker's defense attorney called her a flawed human and said the system and her family failed her. But in the end, it only took the jury 90 minutes to sentence Parker to death.
I'm grateful for the jury. I think their quick verdict was a testament to the strength of the case that the Department of Public Safety put together. They went through the evidence and the law and felt that they had plenty of information to make that decision. So I'm very thankful that they saw the evidence the way that the state did.
Reagan's mother, sister, and husband gave witness statements as Parker cried on the stand. And after that, the judge immediately ordered Parker to be removed from the courtroom and taken to death row. Now, we are told Parker could be taken to the state prison in Gatesville as early as tonight. And then it's worth noting that none of Taylor Parker's family were in the courtroom today.
The case centers on Billy Ray Turner. In 2010, Turner ended the life of former NBA star Lorenzen Wright. He was arrested and charged with Wright's murder in 2017. In court, Wright's mother shared her profound grief and the emotional wounds inflicted by her son's tragic death.
Well, y'all, he was my firstborn child. I told my other kids they need to use him. I used him as an example. Whatever milk didn't work for him, I didn't give it to the other. Whatever pamper didn't work for him, I didn't put him on the other one. He was just the example kid for them. And I used to tell all the time that they got to thank him because a lot of stuff y'all didn't have to go through because he made sure y'all didn't. Let's fast forward to this little boy. He was born a big boy. I'm talking about he was like, I couldn't even hold him like this without holding his head. It was that long. Only back I could hold him like that was his granddad and his dad because they had those long legs. And this boy, for some reason, he never crawled on hands and knees. Both his hands and knees never touched the floor. He crawled on a tiptoe and a hand like this. Not, my mom's called him Mr. Big Stuff because he would never let both his hands touch the ground. And he went from that position to walking at 9 months. He was just something totally, had no baby been in our house in 10 years. And that was my brother. So he was just excited. Everything he did was exciting because we hadn't seen nothing like this anyway in a child this big. Then when he started walking and talking, Lord have mercy. He was a big boy then. Fast forward to 6 years old. I used to have to take his birth certificate to the movie with me to prove that he's 6. Because he was just that big. I carried that.
They were trying to charge you for adults?
Yes, they was. It was so messed up until I got a copy, matter of fact, right now, that he's sending me to keep because the one I had was so folded and crispy, it was like ugly now because I carried it for the years from place to place. And then he started playing basketball, real basketball. He was serious even then. I was like, okay. Then in his pre-teens, he would go to the activity center in my town, and all the other guys, grown men, girl, you know you got a ticket right there. That boy gonna make you some money. I'm like, I don't want y'all to blow his head up. Shut up. You know, he young. Don't let him think this. But as time went on, I went to seeing it myself. Oh my God. What is at home, no sitting room. Because everybody want to see what Red gonna do tonight. And then we got the Oxford and the reason went to the Lafayette, and we got Oxford. That's our route for school. I bet every game we was going to win. I could get the players to come to court right now, tell you how many 50s I got. They paid me because we won. Because of my son. Like, let me tell you what happened here in Memphis. Y'all, I'm hurry up. The guy had knocked Lorenzen down. I'm sitting behind the coach when he tell him to throw a roadblock, but I had no idea he was talking about on my son. 20 minutes later, my son hits the floor. He gets up wanting to hit somebody. Then they push him out the game. He go to the wall talking about he's not going back here. Oh, yes, he is. His dad talked to him and his coach talked. His dad said, I said, boy, I flew over there. If you believe the game, you're going to mess your whole team up because ain't no acting team. You got to stay in the game. And we won. Next game, we had to have police escort in the game because they going to over basketball in high school. I'm not talking about college yet. This is just straight high school. He was just different. I had girlfriends that had nephews and brothers playing on team, but they would come to the games with me so they could be his cheerleaders. Because they saw something and nobody see too, because look at his stats. He just did too well, to be like example. I'm going to start giving y'all examples. He was in the 8th grade and we went to state. If they knew about him being in the 8th grade, they would take the trophy from us because he was supposed to be playing with no high school. But we needed him to win. And that's what we did. Fed High School. I wish y'all could just go look at see what all kinds of trophies he got for them, because every trophy they got, he's on it. It might be just a little inscription under the school, but he's on there. Oh, I'm finna jump way up somewhere now.
You have a lot of stories to tell.
That's why I'm finna jump way somewhere, because I can sit here all day and talk about him. All day. Okay, he gets married. Had me some grandkids. Y'all, my first grandchild was so spoiled, I couldn't let Lorenzen touch him, because he was like, oh, I told him his poop don't even stink, so move. That firstborn was firstborn literally. Everybody, all my friends, everybody know who was my heart. That was Snoop. Firstborn grandchild, he didn't do no wrong in my eyes. I always saw a better way out for him. And then what really got me disgusted about him really getting murdered is called 6. 6 in 1. 6 kids and 1 mom. And my baby grandson has been talking about playing basketball all his life. But when this happened to his dad, he didn't play no basketball. He said, I just asked him why. I would let him just go on and do what he do. And he was like, well, Grandmama, I don't want all the focus on me like it was on my dad. He's the younger brother, and he's tall as the twins. So he would have been a good prospect for the NBA. But he said, no, all this stuff, it changed his total life with my son not being. He didn't have anyone to guide him in no direction. And Laura said, well, maybe Grandma, he just didn't want to play. I said, you mustn't see the Venus and Serena story. They didn't either. But they did. I said, what? Back out there. Sometimes you need your parents in your life to, stay on you. You got to do this. They're children. You got to put some on their mind. You can't just let them do what they want to do. Even, if my son had been here, I would say, Dad, I'm not playing ball. He will write me an essay. Why? Because I don't want to. That's not good enough. You got to have a valid make it make sense. You got to have a valid reason for not doing what I think you can do better than average.
So those grandkids lost a lot.
They lost a lot. Those kids had love all day, every day from their dad.
State is also asking the court to consider whether or not the defendant is a dangerous offender whose behavior indicates little or no regard for human life and had no hesitation of committing a crime in which the risk to human life was high. And again, for enhancement purposes, that if it's implicit to the crime itself, the court cannot consider that for enhancement purposes. But for consecutive sentencing purposes, those are separate things that the court, in fact, can consider separately if it, in fact, raised or proved by the proof in this case or at the sentencing hearing. Mr. Billy Ray Turner had absolutely no hesitation in committing a crime in which the risk to human life is high. Chased Mr. Lorenzen Wright through a wooded area, went to Atlanta, and it has nothing to do with the risk of life being high to an unnamed or an unindicted victim, but the totality of the conduct for which he has in fact been convicted by a jury. went to Atlanta to Lorenzen Wright, was not successful, conspired for a number of time, weeks, at the behest of Shara Wright to Lorenzen Wright. Asked Shara Wright at one point, tell me, Shara, what do you want me to do? Located him, found him, got a text that says he's here, party's on, or something to that effect. Found him, chased him. As Lorenzen Wright is hopping fences, jumping fences, running through a wooded area, literally running for his life. So Billy Ray Turner unloaded a on him, a 9mm pistol on him multiple times. The circumstances surrounding the commission of this offense are in fact aggravated. Court also has to find whether or not the aggregate length of the sentences reasonably relate to the severity of the offense for which the defendant stands convicted and are necessary to protect the public from further criminal acts by the defendant. Not further criminal acts of violence, but just further criminal acts. And that's State versus Wilkerson, Wilkerson, 905 Southwest 2nd, page 933, 1995 Supreme Court opinion, Tennessee Supreme Court opinion. Those are known as the Wilkerson factors, and the court does again find that not only is Mr. Turner a dangerous offender, possess a chase a person with a travel out of state with intent to kill somebody, hatch this nefarious plan to kill this man, comes back to Tennessee, where he's set up by Shara Wright, notified as to where he is, finds him, chases him, with a 25-year history of committing crimes against the state of Tennessee, including kidnapping, aggravated drug offenses, the three worst combinations that you can think of: guns, drugs, violent offenses. Mr. Billy Ray Turner checked all three of those boxes. He is a dangerous offender. He had no hesitation committing this crime, and he has shown over the totality of his adult life that he will continue to commit crimes against the state of Tennessee. I'm ordering that the life sentence that was imposed at the conviction in this case be ordered to be served consecutively to the convicted felon in possession of a firearm, the 16-year sentence that the court imposed on or about June 17, 2019, 1801702. We're going to order that the two 25-year sentences on this case be served concurrently with one another. I could actually impose those sentences consecutively. Also, the state is recommending concurrent sentences, and that's non-binding on the court. The court could actually order consecutive sentences, but I would not order consecutive sentences on the conspiracy and attempted 25-year sentences. Those sentences will be served concurrently with each other, but that 25-year sentence will be served consecutively to count one of this indictment. The life sentence will be served consecutively to the convicted felon unlawfully possessing a firearm. Total effective sentence of life plus 41 years confinement in the Tennessee Department of Correction. Will not impose a fine on these cases. The court does render Mr. Billy Ray Turner infamous on these convictions for which the jury has returned his verdict of guilt. Will give him all the jail credit that he's been in custody towards the release eligibility. I understand that Mr. Turner will, in fact, appeal these convictions. And I wish him good luck on appeal. We'll hear his motion for new trial in 30 days or less. And if Mr. Turner prevails upon the court and says, Judge Coffey, this is why you should grant me a new trial, I would certainly listen to any arguments that Mr. Turner makes at that motion for new trial. Life in Tennessee, what does life in Tennessee mean right now? I have no idea what life means. Every time the legislature goes back into session, there's a movement that says we need to look at what life means in Tennessee. We need to reform sentences, because if you sentence a person to life, that person has to serve 51 years in prison before he can be released. As Mr. Perry argument, that really doesn't incentivize, give a person encouragement to say, let me do well and maybe I can get out of prison before 51 years. I have no idea what 51 years mean. Would next year the legislature go out in session and say we're going to have folks become eligible for release after serving 25 years of a life sentence or 15 years of a life sentence? Because you keep hearing that Tennessee's life equals 60 years, may be one of the longest sentences in this country. So I have no idea what life means. Does Mr. Turner have to serve 51 years of sentence? I don't know. We'll find out next year. We'll find out in 5 years. We'll find out in 10 years. But it would be irresponsible of this court to tell a person who has 9 on that record, 10, 11, now 12 felony convictions on his record, 12 felony convictions over 25 years, that we're going to order all of these sentences to be served concurrently. It is not in the best interest of justice. It is not in the best interest of deterring crimes. If consecutive sentences are not warranted on this case, the state of Tennessee, the legislature needs to do away with consecutive sentences. Mr. Turner has earned every day, every second of this life plus 41-year sentence, with no exception for the record. And we need a date for a motion for new trial hearing. It has to be here within 30 days, 4 weeks from the day.
An all-out melee erupted in court as the youngest person ever convicted of murder in Kent County learned his sentence. Shawn Allen appeared in court where chaos broke out. The situation was sparked by the words of a mother who attempted to explain to the judge why her son shot and killed her live-in boyfriend.
This is a child. Yes, he may have committed an adult crime.
The judge was about to sentence Shawn Allen for second-degree murder when the chaos unfolded in the courtroom.
But obviously, after it all comes out, he was treated in ways that I had no clue of. So we can't say that, oh, he was never mistreated, he was never mistreated. No.
She stated that her live-in boyfriend may have been abusing her son. Relatives of the victim, Charmel Stokes, reacted strongly, leading to a scuffle in the courtroom. Deputies had to wrestle Shawn Allen's uncle to the floor and ultimately cuffed him to restore order. Shawn admitted to walking up behind Stokes and him at the family's Kentwood home. After his arrest, he told a therapist that Stokes had abused both him and his mother. This explanation is the only way his family can rationalize why a child with no prior criminal record would commit such an act.
That was his only way out. He didn't know no other way out. He was a young 13-year-old kid. He just turned 13. That's his only. He didn't know anything else to do.
Police and prosecutors stated that they found no evidence to support the abuse claim and have not identified a motive for the shooting. Relatives of the victim do not believe that he abused anyone.
If there was any abuse, didn't nobody know it. And that kind of secret do not stay in a closet like that.
It was Jose Moore who reacted angrily to the abuse claims in the courtroom, which led to the scuffle.
I couldn't help myself. I couldn't take it no more. I'm hurting bad enough as it is, and then not to express yourself when you're hearing things that's not correct.
It was Shawn Allen's uncle, Chris Mann, on the other side of the courtroom, who was wrestled to the floor. Deputies ultimately released him without filing any charges.
The one I was trying to show a scene and disrespect the court or anything but I'm going through a lot too, and I was just being there for my sister and my nephew, so that's why I kind of reacted like the way I did.
Judge Daniels sentenced Shawn Allen to a juvenile facility until his 21st birthday. At that time, the judge will decide whether to release or transfer him to an adult prison. That was Samantha Klein proclaiming her innocence after the death of a girl in Niagara Falls.
You are an evil monster, and we believe that you are a dangerous person because you killed an innocent, helpless child who could not defend herself.
Crystal Dewson delivered those powerful words to Samantha Klein on behalf of her granddaughter, Alea Foster's family. She urged Judge Murphy to give the maximum sentence, and that's exactly what he did. 25 years for first-degree manslaughter for causing the death of the girl Klein had been trusted to babysit.
I'm sorry. I'm truly sorry.
Klein admitted that she inflicted blunt force trauma on the baby while watching her last February at her home. Judge Murphy questioned Klein about why she waited a day before seeking help for the baby, who was eventually taken to the hospital.
I honestly didn't know what was even wrong with her. She was still eating.
Why didn't you do something to help her?
3 weeks after the death, Klein attempted to proclaim her innocence.
I'm innocent. I did nothing to that baby.
Klein also admitted to selling fentanyl to an undercover officer and being involved in a knife-point robbery in Niagara Falls on Christmas Eve.
There is not enough time, but under the circumstances, I think we're satisfied with the results.
I'm happy that they gave her the 25 years. I mean, it's never going to bring her back, but I'm glad justice was served.
During sentencing, Klein was also given 7 years for the attempted robbery charge and 2.5 years for the criminal sale of drugs. These sentences will be served at the same time as her manslaughter sentence. On December 29, 2016, Kendra Gardner, 25, was found shot in the head at a home on Detroit's East Side. Police reported that her 65-year-old uncle was responsible for the shooting. Another woman in the home managed to disarm him. The uncle, Harmon, was taken into custody and later charged with second-degree murder and felony firearm possession. According to the Wayne County Prosecutor's Office, Harmon and his niece were at a social gathering with other occupants of the house when Harmon became combative. After a brief verbal argument, they allegedly went into another room where Gardner was fatally shot.
On the city's east side. As Jason Colthorpe reports, today's sentencing was less about asking for forgiveness.
It was bad. I didn't have no intention of doing any kind of thing or whatsoever.
She did not deserve to die. I want that absolutely clear. There is no reason.
But she wasn't good. But she was a good person. But when she got to drinking.
The judge sentenced him to a minimum of 12 years and a maximum of 30 for willing.
Judge Slavin noted that testimony revealed heavy drinking by a group of people on the night Gardner was killed. The judge criticized Harmon for attempting to justify her death by calling her a bad person when she was drunk. Testimony showed that Harmon was intoxicated and acting defiantly as Gardner tried to help him to bed. Harmon was charged with second-degree murder and felony firearm possession. A jury found him guilty, and he was sentenced to a minimum of 12 years and a maximum of 30 years in prison. Just a couple of blocks away on Congress Street, a man is accused of stealing a police cruiser with an officer inside. The suspect appeared before a judge in New Haven. Surveillance video shows the moment when police say the man approached the cruiser, got into the driver's seat, and drove off while the officer was still inside. This dramatic incident unfolded outside the police substation on Congress Avenue. Fearing for the safety of others, Officer Carlo Rock pulled the steering wheel, which resulted in the cruiser crashing into a nearby church.
He's just sitting in a car doing a report, unlocks the door to get out to help a citizen, and he's basically kidnapped. The guy jumps in and takes off. He knew he had to bring this to a quick end, and he did. So really respect him, really proud of what he did.
New Haven Police Chief Carl Jacobson visited the church to ensure that everyone was okay following the incident.
It's just about following up, letting the officers in the community know we care about them.
The suspect, 49-year-old Stacy Footman, is facing multiple charges, including larceny, kidnapping, and assault of public safety personnel. He appeared before a judge at New Haven Superior Court.
Mr. Footman expressed to me that he's working through some psychological issues, and this conduct, as you can tell, is mental health related and addiction related.
The public defender representing Footman requested a lower bond, but the judge ultimately set it at $300,000. It has come to light that the suspect has an extensive criminal history, dating back to the early 90s, with police reporting that he has been arrested over 80 times. Footman and the officer both sustained injuries during the crash. Footman is being held at a local hospital under police guard. His bond has been set at $500,000. A man accused of stabbing a woman and stuffing her in a container had an outburst in court, flipping off the judge in anger over his bond being set at $750,000. Meanwhile, the victim is fortunate to be alive. The case has made headlines, with Delonte Edmond Geiger Sr. facing charges of attempted murder. Despite pleading not guilty, he had already confessed to the crimes to police. According to the police, the discovery was made at Geiger's home at 97th and Lorraine after a woman reported that he had shown her photos of the victim tied up in the basement. During their second search of the house, officers heard what sounded like a heavy object and cries for help. That's when they found the woman inside a 3x3 plastic container, motionless, with the lid sealed. Miraculously, she was still alive. She was rushed to a hospital. Edmond Geiger was arrested, charged, and initially held on a $500,000 bond. However, he pleaded not guilty and expressed frustration when the judge increased his bond amount.
$750,000? That's correct, and there's also a probation hold. Well, okay, can y'all lift the hold and at least let me try to post bond? I don't think nobody in the courtroom got $750,000. You'll have to speak with the judge assigned to this case, which is Judge Holly Gallagher. I'm about to fire. I need a new judge. I need a site judge and everything. That's crazy. Why y'all open our fire?
When the judge did not respond to him, Edmund Geiger angrily flipped her off. Regarding the survivor, it's reported that she was on a ventilator. A Detroit emergency medical technician, slashed in the face with a box cutter while on duty, spoke during her attacker's sentencing. She called him a slayer and a psychopath, stating he tried to kill 2 medics who were just doing their jobs. Kelly Adams brought a picture of her bloody face, taken after she and her partner, Alfredo Rojas, were attacked, to Michael Montgomery's sentencing in the Frank Murphy Hall of Justice in Detroit. She told the court that Montgomery left her with scars and mental health issues that will last a lifetime.
So 40 to 80 years in prison for a string of crimes that prosecutors say spanned a decade.
I'm a medic, and my life matters, and that's why I'm here today.
No, not at all.
The police did drop the ball, and so did the prosecutor, and so did the judge.
When you took her and killed her in that alley, you mutilated her body.
Does make parole, he must have a GPS tether for the rest of his life, and he must register as a sex offender.
Montgomery, 31, of Detroit, pleaded guilty to the attack on the EMTs, as well as crimes in 3 cases from 2005 and 2006. He kidnapped and exploited 2 women and murdered Tonya White, a teenager found stabbed in a Detroit alley on January 1st, 2006. Wayne County Circuit Judge Michael Hathaway sentenced Montgomery to 40 to 80 years in prison for his 4 cases, with the sentences to be served concurrently. Montgomery remained silent when given the opportunity to speak, sitting handcuffed with his eyes closed at times during the hearing.
Calling the judge by her first name and then calling her a liar.
When she died, you had to devise a plan, a way to escape what you had done.
Worked tirelessly to solve this, and of course Bianca Jones remains missing.
A former Hialeah police officer is currently on trial, accused along with another officer of kidnapping a man and assaulting him. A key witness in the case, an officer who worked alongside the former officer on trial, spoke. This witness was one of 3 policemen who responded to an initial disturbance at Hialeah Bakery, where they first encountered Jose Ortega Gutierrez.
He's driving me crazy with the same question.
Jose Ortega Gutierrez, the victim of a beating by 2 former Hialeah police officers, finally took the stand after 3 days of testimony, appearing annoyed by the process.
I answered it more than 10 times.
The state then called Officer Jeffrey Abascal, who also responded to the disturbance at the Hialeah Bakery, where Gutierrez was taken into custody. He identified the defendant, Rafael Otano, and pointed out his vehicle at the scene.
Fila and Otano are at the door. That's Officer Otano's target.
Jose Ortega Gutierrez, the victim of a beating by 2 former Hialeah police officers, finally took the stand after 3 days of testimony, showing visible exasperation with the proceedings.
Did he look like this on the day that you arrived on scene?
No, ma'am.
Abascal testified that he had a bad feeling about the behavior of his fellow officer.
There was a lot of policies being violated already, serious policies. So.
He observed them driving out of their assigned sector.
What specifically was it that made you decide not to continue traveling into Sector 5?
I felt that something was wrong.
He later overheard Otano and Orfila discussing the events of the day.
So they took him into Orfila's car, and they both went to Sector 6 to drop him off, and just came back. There was some type of nervousness in there, some type of worry.
Orfila and Otano were assigned to Sector 4. Sergeant Javier Barrios, who was also assigned to that sector, stated that Otano violated policy by failing to activate his body camera or file any related paperwork.
Were you aware at any point that during that call, someone had been taken into custody?
No, it wasn't.
Currently on the stand is an internal affairs detective from the Hialeah Police Department who investigated the incident. She testified that Otano did not file anything in his daily activity report, which police officers complete at the end of their shift to summarize their activities. She noted that for the day in question, nothing had been documented. Jesse Dotson is implicated in this despicable crime. On March 2, 2008, at 722 Lester Street in Memphis, Cecil's lifeless body was found, leading to the unexpected arrest of his brother, Jesse Dotson, for the crime. Despite challenges, the defense advocates for the accused, but justice demands that the court hear all perspectives.
To his family, I'm not going
back to jail. Expect the evidence to show that what he said was, I'm not going back to jail for something I didn't do. State said, well, to put forward some theme, some theory would be just disrespectful. Listen, this is a tragedy. The loss of these lives. Cecil Dotson Sr., Miss Marissa Williams, Hollis Seals, Miss Sherry Roberson, Cecil Dotson II, Samario Dotson. And 3 other victims, these little children, hurt as well. This is a tragedy. And nothing I will say today will make that not true. No proof we could bring to you would make this less than a tragedy. But you know what? It will continue to be a tragedy. It'll be another tragedy unless this is solved. And unless you return the right verdict in this case, they will never solve this case. Because you haven't heard the whole story. You will, though. At the end of this case, the evidence will compel. The evidence will compel a verdict of not guilty. Let's set the scene. Let's talk about this. This scene involves so many people. The media is going berserk. Memphis Police Department is desperate to close this case. They are desperate to get somebody charged on this case. And while they are working through this desperation, they've got the cameras following them around. First 48 has got their cameras going, and they're recreating scenes of what has been done. Wear the same clothes that you wore the other day to recreate the scene. This kind of attention corrupts, it influences, it interferes with good, solid police work. Maybe that's why a lot of good, solid police work was not done. That is not for me to explain to you or answer for you, but it is to be answered. And as they're going through this, there's this intense rush to get it done. Because the show's not called Morally Certain. The show is called First 48. Get it solved in the first 48. State says that this is a domestic violence assault. Then the witnesses and an eyewitness. And he says. And they also bring in, he says, this is what happened. If only there were a way we could be certain of every word that was said. If only there were some technology that would allow that. Let's talk about the state. Jesse has just been released from jail. He was there when his family was. He was there. He hid. He's got with no bullets. When he gets up, when they're gone, he gets up. Everybody. Now, of course, the proof is that 3 children were not. But that fooled even the first responders, the police officers and the paramedics. They walked in upon these children, and one of them woke up and scared the officer. To all appearances, everybody in the scene is. He runs away. He lived through it. It was traumatic. He didn't tell anyone. I expect the evidence to show you that there are reasons for that. He has no reasons to trust the police. He certainly knows there are gangs to be afraid of. You're going to hear quite a bit of proof about that. And he says, I'm not going back to jail for something I didn't do. Expect that to be what the state's witness says that he said. He's arrested days later.
The sheer brutality of the crime sends shivers down spines at the mere mention of its details, painting a horrific picture of its depravity.
The crime scene. The proof will show, after the bodies were removed, in that small living room, male victim was laying right here, female victim here, another female victim here, and then over down here is the other male victim. In the bedroom, all over the walls, on the blinds, on the bed, and the pillow right here, the proof will show is where Cecil Dotson II was laid to rest. His brother, Cedric, still alive, was around right here. In the final bedroom, looks like a child's room, of course, Samario. The proof will show that's where his head was laying. In the bathroom, with all over it, the proof will show that's where CJ was found, in that tub with that in his head. And then they start to look around. Sergeant Mullins will tell you that as they started to move stuff around, they started to find shell casings under stuff. When they moved a jacket, they found those shell casings were all picked up and put in a Ziploc bag. Sergeant Mullins will tell you that they didn't see it because it was under a jacket, and the person or persons responsible for this at that point must have left those behind. They begin to find knife blades all over the house with no handles on them. Two of the knife blades were in the tub under CJ. There was a knife blade in the corner of the bedroom where Cecil Dotson II was. And there was also a bent knife blade in a pillow on the bed in the room where Cecil Dotson II was found. And in the kitchen, an overturned silverware tray. At this point, ladies and gentlemen, the proof will show that there were 4 blades found at this point and only 1 knife handle. The proof will show they tore that house apart and couldn't find the other handles. And then the 5th blade, ladies and gentlemen, the proof will show was in CJ's head. You will hear testimony from Dr. Malbauer, who removed that from CJ's head. Miraculous story. CJ's alive, he's doing well, and he's back in school. What are the only things they found? They began to find boards inside this house with blood on. A board propped up against the wall, another one shoved under here, all had blood on them. 2 boards in the bedroom where 4-year-old Samario lay by those bunk beds. And then a long 2x4 with all over it in the same room where little Cecil Dotson II was laying on that pillow and his 5-year-old brother clinging to life. Board pieces in the toilet, as well as propped up in the bathroom. Forensic evidence. With a scene like this, everything started to get collected. The proof will show they were swabbing everything, dusting everything, taking samples out of the carpet, cutting the wall out, everything that they could do to try and find some evidence of who did this. The proof will show that every bit of in that house, you could tie it to a bed.
Criminals' mental strength allows them to manipulate with calmness, blurring the line between truth and dishonesty, and challenging the perception of reality.
When you left that apartment, it was still the three of you, or was it still the three of you?
Three of us.
Where did you go next?
To Sheila's house.
And who was Sheila?
That was my girlfriend at the time.
Do you remember the name of the street she lived on?
Silver.
What happened when you got to Sheila's house? What did you do?
Well, we got out the car. Me and my brother got out the car, went in. I was looking for Sheila. She wasn't there. And her daughter told me I could look around. I looked in her room. She wasn't in her room. So her daughter jumped in front of her bedroom door. So I said, why are you jumping in front of the bedroom door? You said I can look around. So she moved out the way. She went in her mom's room. I opened up the bedroom door. Her boyfriend was sitting on the floor. She didn't have a bed in there at the time. He had just moved in there. He was sitting on the floor. He had his pants halfway down. So I told him, I said, oh, I'm sorry. I bagged out. So she got to cussing me out, and I told her I was sorry. And my brother told her, he in love, he drunk, he in love. She was like, this ain't no love. Love gonna make you. So, we left. We didn't stay. We left there, went to my son's house.
Okay. You went to your son's house next. What's your son's name?
Well, we didn't go to his house. We went to his grandmama's house.
What's his grandmother's name?
Marilyn.
How long did you stay at his grandmother's house?
We didn't stay there 5 minutes. He wasn't there. He was at his auntie's.
Did you see his grandmother? Did you see anybody there?
Yeah. Saw his sister and his grandma.
Where did you go next?
Went to pick Sandra up.
Where was that? Do you know?
It's right next to G.E. Patterson Church. Some apartments right next to G.E. Patterson Church.
Why were you picking up Shindry? Who was she in relationship to the three of you?
E. Just picking her up for E.
Was it his sister, his mother, his girlfriend? Who was it?
His girlfriend.
Where did you go after picking up Shindry?
Well, when Sandra got in the car, she asked if we had some weed. Said no. Said we just left Franknum house, and brother said he not going back to Franknum house. So he said he got somewhere to go. That's when we went to the Chemical Cabana.
Kimball Cabana apartment. Is that an apartment complex?
Yes, sir.
And what did you do at Kimball Cabana Apartments?
Well, we pulled up. My brother got out the car. Well, Sandria said she had $15. And I gave $30, which we spent $45.
Buying marijuana?
Yes, sir. So my brother got out the car, come back to the car, told me to get out the car. He wanted me to meet some of his folks. So I got out the car, went in the apartment. He introduced me to some of his folks.
All right, let me back you up a little bit. The apartment you went into, is that the apartment you bought marijuana from?
Yes, sir.
Okay. When you use the term folks, when your brother said, these are my folks, what does that term mean, folks?
Gangster disciples.
How many folks were in that apartment?
4.
Did you know them before you went into that apartment?
No, sir.
How long did you all stay in that apartment?
Well, we stayed in there about 10 minutes.
When you left, how many people left in your car with you?
4.
4. The same 4? You, your brother, Paulus, and Jimmy?
Yes, sir.
Where did you go next?
To... I don't know her name, but I described her to the detectives as a big girl.
A crime can be viewed from various angles. The jury delivers its verdict after considering factors such as the nature and extent of the crime.
Verdict form for count 1 of the indictment reads, we, the jury, find the defendant guilty of the first degree of Cecil Dotson Sr. as charged in the first count of the indictment. The verdict form for count 2 of the indictment reads, we, the jury, find the defendant guilty of first degree of Marissa Williams as charged in the second count of the indictment. The verdict form for division for count 3 reads, we, the jury, find the defendant guilty of in the first degree of Hollis Seals as charged in the third count of the indictment. Verdict form for division for count 4 reads, we, the jury, find the defendant guilty of the first degree of Shindry Roberson as charged in the fourth count of the indictment. Verdict form for count 5 reads, we, the jury, find the defendant guilty of the first degree of Cecil Dotson Jr. II as charged in the fifth count of the indictment. The verdict form for count 6 reads, we, the jury, find the defendant guilty of the first degree of Samario Dotson as charged in the sixth count of the indictment. The verdict form for count 7 of the indictment reads, we, the jury, find the defendant guilty of attempted murder in the first degree of Cedric Dotson as charged in the seventh count of the indictment. The verdict form for count 8 of the indictment reads, we, the jury, find the defendant guilty of attempted murder in the first degree of Sanaya Dotson as charged in the 8th count of the indictment. And the verdict form for count 9 reads, we, the jury, find the defendant guilty of attempted murder in the first degree of Cecil Dotson Jr. as charged in the 9th count of the indictment. The court will accept the verdict of the jury. Mr. Dotson, if you would stand, please. Mr. Jesse Dotson, after a trial by jury of your peers, jury having found you guilty of the first degree of Cecil Dotson, Marissa Williams, Hollis Seals, Shindry Roberson, Cecil Dotson Jr. II, and Samario Dotson. As a judgment of this court, you be convicted of that offense. We will go forward with the second portion of this trial immediately following these proceedings. And with regard to Cedric Dotson, Sanaya Dotson, and Cecil Dotson Jr., the jury having found you guilty of attempted first degree, it's a judgment of this court, you be convicted of those offenses. I will schedule those matters for a sentencing hearing. The court finds as a 13th juror that it agrees with the verdicts of the jury at this point, up to this point, that those verdicts are based upon the law and the evidence. And again, as a 13th juror, I would concur in those verdicts. All right, sir, you may be seated. It's my intent to begin the second phase, I think, in the morning. I think everybody needs a chance to get all their issues together, and we should be ready to proceed first thing in the morning. So I'm going to send the jury out for the evening.
In court, punishment is given if guilt is proven. The judge determines the appropriate punishment for the convicted criminal.
We, the jury, unanimously find that the state has proven beyond a reasonable doubt that the statutory aggravating circumstance or circumstances so listed above outweigh any mitigating circumstances. Therefore, we, the jury, unanimously find that the punishment for the defendant, Jesse Dotson, shall be. It is signed by all 12 jurors. Again, as a 13th juror, I concur in and accept the verdicts of the jury as proper. Mr. Dotson, would you stand, please? Jesse Dotson, after trial by a jury of your peers, the jury having found you guilty of the first degree of Cecil Dotson Sr., of Marissa Williams, Hollis Seals, of Shindry Roberson, of Cecil Dotson Jr. II, and of Samario Dotson. And further, the jury having imposed a sentence of death upon you, it's the order of this court that you be taken by the sheriff and remanded to jail, and at the earliest convenience that you be delivered to the warden of the state penitentiary, therein to be confined until March the 2nd of 2012. And on that day that you receive a of based upon the laws of the state of Tennessee, sufficient to cause your death. May God have mercy on your souls.
This next story seems more like a horror movie than a real event in a local community. What began as a tip involving kidnapping, starvation, and beatings quickly turned into a rescue mission. 62-year-old Frida Underwood had her chance to speak in a Clermont County courtroom. Frida sat in court alongside the Union Township Clermont County police officers who rescued her from Ellis and his partner, Colleen Haynes. The couple had initially offered to care for Frida, who was disabled.
Because she knows, I know, this court knows that this is one nightmare that Miss Underwood's never going to wake up.
Tim Ellis pleaded guilty to kidnapping, assault, and stealing Frida's Social Security checks. During today's sentencing hearing, evidence included a photo showing what Frida looked like when police found her. She weighed only 92 pounds, surviving on just one sandwich a day. Other photos revealed her chemically hands, caused by being forced to clean them with bleach without any gloves.
I think that he really deserves to be punished for the way he treated me.
The judge agreed.
It is suggested that if the defendants were left to their own devices and without police intervention, the victim would either be in a continued state of imprisonment today or possibly even deceased.
Frida quietly celebrated when the judge sentenced Ellis to 21.5 years in prison.
They threatened me that if I said anything to the police, that they would find me and kill me.
And she wasn't able to use the phone, wasn't able to leave the apartment, wasn't able to communicate with other people in the apartment complex. Obviously, that was a systematic purpose to maintain control over her and to take money from her.
Now, Frida lives in a residence with other seniors, where she looks forward to arts and crafts and dancing. Travin Baskerville stood trial for the murder of Douglas Calhoun, also known as Chef Doug, and the human trafficking of a Detroit girl. He was found guilty and received a 120-year prison sentence. Baskerville was convicted of second-degree murder, human trafficking, involvement in a criminal enterprise resulting in death, human trafficking of a minor for criminal sexual activity, child exploitation, being a felon in possession of a firearm, and a felony firearms violation. He was sentenced to 60 to 100 years in prison for the second-degree murder conviction and another 60 to 100 years for the human trafficking conviction, with the sentences to be served consecutively. This means Baskerville will not be eligible for release for at least 120 years, effectively a life sentence. Baskerville killed Calhoun on June 1st, 2017, following an argument at Baskerville's home on Burgess Street.
The man convicted of killing a beloved former Marine, chef, uncle, and brother learned his sentence today.
120 years, but the judge and the prosecutors decided that these two different counts of murder.
With the awful imagination of how his life ended so tragically.
That Ms. Baker is not necessarily a victim in this case. She's also what we believe to be one of the shooters.
The Wayne County Prosecutor's Office revealed that Baskerville had been involved in the human trafficking of a girl. On June 1st, 2017, the girl called Calhoun and arranged to meet him at Baskerville's home. When Calhoun arrived, he got into an argument with Baskerville, who then fatally shot him. Baskerville took Calhoun's body to a vacant house, where it was discovered on July 7th on Grail Avenue. The girl led police to the body, and the medical examiner confirmed Calhoun died from gunshot wounds. Baskerville's ex-girlfriend testified that Baskerville frequently arranged meetings for the girl. An ad had been posted online for these services starting in 2016. During her testimony, the witness stated that the argument began after Calhoun made a demand that escalated the situation, leading to Baskerville shooting him. She also described how they disposed of the body. The prosecution played a phone recording in court, where Baskerville, calling from jail, instructed his ex-girlfriend to remain silent and offered to take the blame for the crime. A local man avoided a murder trial by pleading guilty in court, but not before a fight broke out between the families of the victim and the defendant. Jury selection was set to begin for Leonard Lanier when the scuffle erupted as he was leaving the courtroom to discuss a plea deal. Two deputies sustained minor injuries, and the prosecutor was shoved, causing her glasses to break. The judge sentenced Lanier to 28 years in prison for involuntary manslaughter after he shot and killed his former girlfriend, 21-year-old Strawberry Edwards, on Dutch Colony Drive. Edwards was 3 months pregnant at the time. The courtroom altercation involved her brother, Jason Edwards, and Lanier's brother, Lucian Edwards, along with Lucian Ruther. Jason Edwards will serve 5 days in jail for contempt and assaulting a police officer, while Lanier will serve 30 days. Derek Brown, found guilty of assaulting a woman in River West Park, caused a major commotion in a Milwaukee courtroom during his sentencing. When allowed to address the court, Brown went on a rant, turning to face the camera directly while proclaiming that he was the real victim in the case. He entered the courtroom with a smirk, showing no remorse for the unthinkable crime he committed against the woman in the park on Bremen Street.
And I'm going to let y'all know how bogus they are. They are bogus. They are heinously convicting me and sentencing me, and I'm going to get out of here, and I'm going to speak to the world. You hear me?
We're not going on with this argument.
Trayvon Martin, Dante Hamilton, I am a victim. I am going to be victorious.
Turn the microphone off.
Turn the microphone.
This was Derek Brown's sentencing hearing following his conviction for an attack that took place. His DNA had been linked to the crime. The victim shared a photo on social media from the hospital where she was being treated for her injuries. According to the court, Brown approached her with a gun pressed against her back while she was walking along Bremen Street. He forced her into a nearby park and threatened to rape her, but instead, he began brutally beating her. Her screams for help were heard by someone nearby, prompting Brown to flee the scene. Despite this, Brown showed no remorse. As he was escorted out of the courtroom, he smiled at the camera and repeatedly shouted, "God has my back."
God has my back.
The judge sentenced Derek Brown to more than 44 years in prison, followed by 22 years of extended supervision. During the hearing, the judge also read a statement from the victim, who shared that she continues to suffer from the physical injuries she endured during the attack, and is still dealing with the mental torment caused by the incident. Marcus Hightower, a Detroit man, was sentenced for the murder of a girl and her mother, a crime that prompted an Amber Alert and caused mass chaos. Hightower, 34, pleaded guilty to 2 counts of second-degree murder and 1 count of third-degree arson. He was sentenced to 50 to 75 years in prison for the murders and 6 to 10 years for the arson. Michigan State Police issued an Amber Alert for Savannah Walker and her mother, 39-year-old Heidi Little Walker, who had been missing for several days. Hours later, their bodies were discovered in an abandoned, torched home on Lakeview Street on Detroit's east side. Hightower turned himself into the police the following day. Before his sentencing, Hightower spoke, claiming that if he had received a proper psychological evaluation upon his release from prison, the tragedy might have been prevented. He accepted responsibility for his crimes, but explained that he had recently been diagnosed with bipolar disorder. He suggested that Savannah and Heidi Walker might still be alive if his condition had been managed and medicated.
She was
Hightower had a history of criminal violence and was on parole for an assault with intent to commit murder. He was reportedly traveling in a black 2004 Ford Explorer discovered on Detroit's east side. Detectives searched the home of Hightower's relative, using cadaver dogs to look for evidence that Savannah or her mother had been there. His house was less than 3 miles from where the bodies of the woman and child were found.
He does, Dave, dating all the way back to 2001. Now, he wasn't dating Heidi, and police have a very...
I don't think he should be eligible for parole in 50 years, but that doesn't mean he's going to get out.
He'll serve 6 to 10 years concurrently, meaning he'll serve that time while he is serving his time for the murders.
While we need to have a conversation with him, you will not hide, you cannot hide, we will find...
6 former Mississippi officers were sentenced to 15 to 45 years in prison for their roles in the assault and torture of 2 black men. The officers pleaded guilty to various charges, including hindering prosecution, burglary, home invasion, and aggravated assault. This group, which referred to themselves as the Goon Squad, had previously pleaded guilty to federal charges last year and received sentences of 10 to 40 years in prison. These law enforcement officers admitted guilt for both federal and state charges, most of which were felonies. The case happened when a white neighbor called a sheriff's deputy, expressing concern about 2 black men entering a white woman's home. The deputy then mobilized the Goon Squad, known for their excessive use of force. They entered the home without a search warrant and brutally tortured the men for about 90 minutes, subjecting them to physical, sexual, and psychological abuse. The situation escalated to the point where one of the men was shot in the mouth. In an attempt to cover up their actions, the officers planted methamphetamine and a gun on the victims, charging them with drug possession. However, the charges were later reversed, leading to the current sentencing of the officers. The two victims, Michael Jenkins and Eddie Parker, have filed a $40 million civil lawsuit against the Rankin County Sheriff's Office. Victims and their families described the sentences as monumental, especially since the state had recommended much lighter penalties. They delivered victim impact statements in the courtroom through their attorney.
My life was not perfect, but it was mine. I doubt if I'll ever experience it again. I wish I didn't have to experience the memory of this torture session, but I can't do that either. I can't erase my memories, but I will struggle to live on.
Now, attention has shifted to the Sheriff's Department, where calls for Sheriff Brian Bailey to resign are growing louder. Critics allege that there are systemic problems within the department and claim that he was aware of these issues. They believe it's time for him to step down. The victim in the serial rapist trial shared the terrifying details of her assault, but it was what she revealed happened afterward that left the entire courtroom in shock. She stated that right after the attack, E.K. Smith spent nearly an hour talking to her about religion. This unexpected testimony was given during a hearing in Dearborn Heights. The victim told the court that she had been raped once before, years earlier. On the night Smith allegedly entered her home, she was determined to protect herself and her child, who was sleeping in the next room. Instead of fighting back physically, she chose to rely on the power of prayer. Now, back in court in Dearborn Heights, E.K. Smith faces accusations of raping multiple women over several years. However, the focus was on a case from 2013. On the witness stand, the woman described how she was jolted awake from her sleep.
I rolled over in bed and I saw a flashlight in the doorway.
She testified that a man jumped into her bed while her child was in the next room.
I'll hurt her, I'll hurt you. He held a knife to my neck.
The woman testified that she told her attacker she had been raped before.
Trying to make him see me as a person, to have sympathy for me.
Smith is accused of briefly backing off.
I still have a desire, I still want to do this. I want you to feel how excited I am, and he took my hand and made me touch him.
The court listened as she explained that she began praying out loud, not for herself, but for the man in her room.
He got off the bed and walked around in circles, and he said, "Why did I pick this house? Why did I pick this house?" And I said to him, maybe it's because God wanted you to hear a message.
For over 45 minutes, she pleaded with him. Eventually, he began to share details about his childhood and how his mother was a drug addict.
Out of that, he ended up in foster care, and while he was in foster care, that he was sexually abused by one of his relatives, and so that he blamed his mother.
The victim provided some chilling testimony, stating that Smith told her the devil had driven him to enter her home and attack her, as well as the other women. Prosecutors revealed that Smith eventually left without further harming the woman in Dearborn Heights back in December 2013. He now faces charges of sexual assault, home invasion, and torture, and the judge has decided to move forward with the trial. It was clearly a harrowing ordeal for the woman, having to deal with him for 45 minutes. In court, Smith was seen staring straight ahead, occasionally glancing down as he flipped through the pages of a Bible. He left the courtroom with the Bible in hand, though prosecutors suggest it's too late to believe the woman had any meaningful impact on his life. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.